for judgment item 1.
For reasons mentioned in the judgment, we are constrained to give benefit of doubt to the appellant and acquit him of charge under section 6 of the POCSO Act. The impugned judgment of the trial court is accordingly set aside. The appellant shall be released forthwith if his detention is not required in connection with any other case.
Item 20.
For reasons mentioned in the judgment, the appellant is acquitted of charge under section 6 of POCSO Act. The impugned judgment of the trial court is set aside, and the appellant is shall be released from custody if he is not required in connection with any other case.
May I please, Your Lordship, with reference to item number 3, 6 and 9, my Lord, if this matter may kindly be listed after the ensuing vacation, my senior have some personal difficulties.
Item number
3, 6 and 9. I'm appearing on behalf of my senior, Mr. Jordan Romintanga.
3, 6 and 9.
It's stacked together with...
Except item 2, items 1 to 14 are the matters pertaining to the same issue.
Item number
1 to 13, excluding item 2. So if these 3 items are going to be adjourned, my humble submission would be that let all the cases be taken up together on that day.
What is the matter?
The matter is with regard to its cycling of the money from Mahindra Finance Services Limited by the branch head and in connivance with many persons, including some of the dealers of the car dealers. So 3 FIRs came to be registered with regard to the offences under various sections, including 467. So some bail applications, some question petitions, etc., they are all overlapping and interconnected.
What relief you are seeking?
My senior have some personal difficulties, Mr. Jordan.
No, okay,
Romintanga.
I'll 3, 6 and 9 will be adjourned. And
all the matters are clubbed together.
Items
3, 4, 5, 6 are clubbed together.
oh yes, 3, 4, 5, 6 are clubbed.
All clubbed together because they are
So
related to the same subject matter.
So these 4 may be adjourned.
And your 7 to 13, my learned senior friend is fit to file there.
We are public praying to seek some time to file our reply to the petitions.
Okay, let me pass orders on item number 3 to 6. What is your name? Miss?
Lalrina Mitsakswa.
Your name is not there in the
I'm appearing on behalf of my senior,
Okay,
Mr. Jordan
heard
Romintanga.
Miss so-and-so appearing on behalf of Mr. C. Zoram Chana.
No, Mr. Jordan Romintanga, my lord.
Okay, respondent number 2,
Yes.
Mr. Jordan Roming Tanga, learned counsel for respondent number 2. Who is for the petitioner?
Let's
Also heard Mr. C. Zoram Chana.
I am instructed. My name is Naresh Kaushik, Senior Advocate.
Oh,
I am
you are
instructed.
leading. Also heard Mr. N. What is your name?
Naresh Kaushik.
Mr. N. Naresh Kaushik, Learned Senior Counsel, assisted by Mr. C. Zoram Chana, Learned Counsel for the petitioner. Learned Counsel for respondent number 2 prays for an adjournment on the ground of personal difficulty of the conducting counsel for respondent number 2. You are having no objection to
2 minutes personal difficulty.
the counsel for the, and PP is also having no, Learned also Miss Linda M. L. Farmwell, Learned Public Prosecutor, Learned Counsel for the petitioner as well as Learned Public Prosecutor does not oppose the prayer of adjournment made by respondent number 2, hence same is allowed. Let this matter be these matters be listed after 3 weeks on a date to be fixed by registry.
It's, some of the honorable judges have recused themselves from the matters, and I have been assisted by my learned colleague, Mr. Malhotra. The bench which can hear the matter is assembling on 28th July till 7th August. So any
No, you are for respondent number 2,
Petitioner.
Mr. Kaushik.
no, in these matters I am for the petitioner.
You are assisted by Mr. Zoram Chana.
Yes.
Okay.
So any dates in that period where the honorable judge can hear the matters and has not recused.
You suggest?
It's 5th August.
Okay. Let this matter be listed on 5th of August.
That
And other matters,
it's items
7, 8,
13, 7 to 13.
7 to 13.
They are all connected.
They are all connected. I am humbly praying 2 weeks time to file my reply come objections to the petitions.
in item number 7 to 13, heard Mr. N. Kaushik, Learned Senior Counsel, assisted by Mr. A. R. Malhotra, Learned Counsel.
Caesar and Selachi.
No, 7 to 13?
My lord, I assisted my learned senior counsel. Caesar Ramsana. Mr. Malhotra is on the other side.
No, but in item number 7 you are not there.
Your name is not
7 to 13. In item number 7 to 13, Mr. Malhotra is for the petitioner.
Yes, it's, I am instructed to say that the direction was given to amend the cause title and include the name to the petitioner in this matter as per the last order.
Who is for the petitioner in item number
Malhotra is
7?
for the petitioner.
Mr. Malhotra, you are there.
7. Yes.
Item number 7, who is for the petitioner?
Your Worship, I'm there for the petitioner, Your Worship.
You decide amongst yourself who is appearing.
Sorry, Your Worship, I'm for the petitioner.
You are leaded by Mr. Kaushik.
Your Worship,
No.
I'll clarify the matter, Your Worship, because initially when the petition was filed, Mahindra was not made a party. So in case there's a subsequent order impleading them, then we'll make an amendment to the cause list, to the cause title.
It was miscellaneous application, yes.
Oh, then Mahindra came.
Yes.
As respondents,
As respondent number 2.
Mahindra came as respondent number 2.
My lord, yes. By filing IA miscellaneous application.
So,
under
petitioners-
section 301.
Remain the same.
Yes.
Mr. Malhotra, Learned Counsel for the petitioner, also in 7 to 13. Huh?
The 13 is amendment.
13 is also similar matter.
Similar matter, but the council is different. So you need to.
No, Mr. Malhotra is there for everyone.
Your Worship, I'm there in 7, 8, 10, 11 and 12. In 9, it is Mr. Jordan, and in 13, my learned friend, Miss Dinari. I'm there in 7 and 8, 9, 10, 11 and 12.
Okay, the submission remains same. In 7 to 13, the respondent number 2 is seeking leave for filing.
Reply come counted.
In 7 to 13, other thing will remain as it is. Only learned senior counsel for respondent number 3. Respondent number?
2.
Respondent.
You have included here, item number 13, they are respondent number 3, Mahindra.
Lordship may indicate by the name of
Okay,
the complainant.
learned. Uma Koyas. 7 to 13. Mr. A.R. Malhotra.
13 is not Malhotra. Malhotra is 9, 10, 11 and 12. 13 is my case here.
9 is Jordan.
I
9
mean,
is Jordan.
8, 10, 11, 12. Right. 7, 8.
11, 12.
Abhishek. 7, 8, 10, 11, 12 and 13.
13 is my case. I have made the party, Mahindra.
13, who is for the petitioner?
Me, Your Lordship, Dinari.
But here also name of Mr. Malhotra is shown in the cause list.
No,
In
13 is not. 13.
Oh,
One,
in 12.
item number
Okay,
1,
okay, okay. 7, 8, 10, 11, 12. Counsel for the petitioner is Mr. A.R. Malhotra. In 13, counsel for the petitioner is Ms. Dinari T. Azyu. In 12,
In 9.
in 9, Ms. Lalrin Wami. Who, what is your name?
Lady name is Sakwa.
Take her name. Appearing on behalf of Mr. Jordan Roming Thanga, and in all the cases, the state is represented by Ms. Linda M. Farmwell, learned public prosecutor, and the respondent Mahindra and Mahindra Financial Service Limited, represented by Mr. N. Kaushik, learned senior counsel, assisted by Mr. C. Zoram Chana, who prays for some time for filing reply to the written objection against the petition filed by the petitioner, and prays for some time for the same. The prayer is allowed. Let these matters be listed on 8th of August.
Great.
Admission, item 2.
So as Your Lordship's indulgence in mentioning item 5 of part 2.
Number 1 also needs.
Item number 1 has to be called. 1.
has not been called.
1 is not mentioned. 1 has to be called. Yes, Mr. Pautu.
My Lord, even though the matter is fixed for today, Miss Mary is absent. I learned that.
Which
Miss Mary
one?
is absent. Item 5 of part 2.
Item 5 of part 2.
Yes, my Lord.
Item 5 of the hearing list.
Yes.
Heard Mr. Lalrokunga Pautu, Learned Counsel for respondent number 2. Who is for the appellant?
My Lord,
What is your name?
Miss Bila Ramnelli.
Ms. B. Lalram in Nemi, Learned Amicus Curie, appears for respondent, appears for the appellant.
But the reason for her absence is that her mother is having an operation today.
Learned Amicus Curie has submitted that he has been informed by Learned Additional Public Prosecutor Ms. Mary L. Chiante that she has some personal difficulty today and has therefore prayed for some accommodation. The prayer is allowed. Let this matter be listed
After vacation,
after 2 weeks on a date to be fixed by registry.
I'm obliged.
Motion, item 1.
Yes.
This is a fresh matter. The issue involved is with regard to the considerations of the provisions of section 47 of the section 50 of the CRPC, read with article 21 of the Constitution, requiring the accused to be provided with the grounds of arrest. In the instant case, before the arrest had taken place, the accused had approached the Honorable Court for grant of anticipatory bail. In respect whereof, the state as well as the complainant apprised the Honorable Court with regard to the grounds on the basis of which the custodial interrogation of the accused was necessary. On being satisfied, the Honorable Court adjudicated the issue, rejected the anticipatory bail, vacated the stay which was obtained on the first date of hearing, and thereafter, on 13th April, the matter was decided on 4th April. On 13th April, the accused came to be arrested. So my submissions in this case are threefold. First and foremost,
What happened thereafter, after arrest
after
of...
Millets, he was in one case, which is the connected matter. His anticipatory bail was rejected in one case. In the other case, bail was allowed on the ground that the interrogation in the another case, which is connected to this case, should be sufficient for the purpose of investigation, as a result whereof the anticipatory bail can be allowed in the second case.
No, what happened in this case?
In this case, afterwards, now he has, after having been arrested, the charge sheet having been filed, in the aftermath, this person approached recently saying that my arrest at that point of time was in violation of provisions of section 50 CRPC and article 22(1) of the Constitution. Therefore, I need to be released in the context of violation of these conditions. I am entitled to be enlarged on bail. By the impugned order, the learned trial court has allowed the benefit of these provisions and passed an order of grant of bail, enlargement on bail, which I am challenging on primarily three grounds. First and foremost is that the precedents cited by the respondent before the Honorable Court in two cases primarily, that is Pankaj Bansal and Pradeep Puriakast, that is 2023 and 2024, these two decisions, which are exhaustive decisions rendered in the context of PMLA and UAPA cases. And the interpretation and ratio laid down is not attracted in the other cases in the context of the language of section 22(1) and section 50 of the CRPC, article 22(1) and section 50 of the CRPC. So in my humble submission, those precedents are distinguishable and are not applicable so far as the facts and circumstances of this case are concerned. Secondly, my humble submission is that as an afterthought, after much passage of time and rejection of bail applications on merits, this provision would not be applicable, would not be attracted. It is one thing that if he had not approached the honorable courts for grant of bail at all, and for the first time he raises these aspects, then the court may consider. But after a long lapse of time, nearly a year, as an afterthought, after much water has flown down the river, this...
Whether in this case grounds of arrest were informed to the arrestee
In my humble submission, they were informed
at the time of his
at
arrest?
the time of arrest, which is reflected by the arrest memo, which clearly lays down the provisions under which his arrest was sought. The contents of the FIR are clear enough to indicate to him as to on what basis, on what ground.
Where is that?
Kindly minutes come to.
At the time of his arrest, he
Yes,
has.
let the arrest memo, kindly see.
Whether notice under section 50 was furnished to him?
In my humble submission, minutes, page 37 indicates.
Page,
No, the
page.
arrest memo. May I hand over to your lordships the written submissions filed before the learned trial court, which contains all these documents. That was
No,
not-
in your criminal petition, have you not annexed that?
They have not come on record. So if your lordships desires, I can bring them on record.
Okay, you may file
Yes,
And
this
any-
ought to have been filed minutes along with.
you may file,
Kindly.
but where is that arrest?
That
memo?
is minutes at page 12 of this compilation. And page 13, the first line itself says.
What is this?
This is the arrest memo, arrest cum surrender form. The sections are indicated. And page 13, top first line, para 8, the accused after being informed of the grounds of arrest.
No, how they were informed? The requirement of law is that a notice has to be served on them under section 47 of BNS or 50 of CRPC.
It's my humble submission, that is why I started by making a submission, that the context of informing in writing by a communication is not attracted to these type of cases, because that law has been elaborated upon and exposition has been done in the context of PMLA section 19, whereof lays down that requirement. Here, kindly see in section 50, the only word is information.
What case was it?
Section 50 of the CRPC.
You have gone through Vihan Kumar.
I have gone through Priyakayast and Pankaj
And
Bansal.
Vihan Kumar's case?
It's Vihan Kumar's case has not been brought to my notice. If I can,
Laptop law. Just bring the laptop.
that is Honorable Supreme Court's.
Yes, Vihan Kumar is the latest judgment. Vihan Kumar versus State of Haryana.
State of it.
You may find out the citation. Your main contention is that requirement of issuance of a written notice, furnishing the grounds of arrest in writing is not necessary.
Is not necessary in the cases which are not governed by the provisions of PMLA Act and UAP Act.
Okay. What is the requirement in those cases?
In those cases, the requirement is information of the grounds of arrest by whatever mode. In writing, communication is not there because 22(1) in contradistinction to 22(5).
Suppose this fact is in dispute, that whether the grounds of arrest have been informed or not. How the court will ascertain?
Fortunately for me, in this very case, the acknowledgement is given of this aspect by the accused by signing this memo at page 14. Signature is at column number 14.
By signing what he is implying?
He acknowledges the contents of this arrest memo.
How we came to that conclusion?
In my humble submission, he would not have signed this. If
No, he was asked to sign on the paper by police. He signed it.
on perusal only, he would have signed it.
But it is not written there that I am signing it after reading the contents. And
Secondly, I am going to the next stage. At page 15 on the same very day, the remand application also, which was supplied to the accused, on the same very day contains the grounds. Apart from that, I'll straight away come to the main thrust of my submission. Kindly see the order of the Honorable Court, which adjudicated the bail application, by virtue of which he was.
where is the impugned order?
Impugned order is page 4. Annexure 4 minutes.
Page 14. Page 14.
Page 49.
Okay, thank you. Yes.
Yan Kumar ka citation मिला? Right on. Citation 2025 INSC. I have got it's the soft copy of Vihan Kumar.
In Vihan Kumar, which case was involved?
IPC.
You find out.
Yes, please.
This may be relevant. We
Yes,
are not
it's
going
your
into
lordship
those
is right,
aspects.
it's exactly the same offences which are involved in this case. 460, 420, 468, 471.
So Vihan Kumar is relevant to your case.
Yes,
In Vihan Kumar also, the Supreme Court has
followed.
observed that
Yes,
it is necessary to give the grounds of arrest in writing.
correct.
Still, as this matter is similar to all other matters, many other matters which were listed today, we are issuing notice.
Very well. I'm grateful. Yes.
But here you have
I'll
not.
come better prepared in this regard.
Here you have not made the accused. Have you made the accused party? Zakir Hussain responded. Okay. Okay. Heard Mr.
Yes, please.
N.
Page 3.
Okay. Heard Mr. N. Kaushik, Learned Senior Counsel, assisted by Mr. C. Zoram Chana, Learned Counsel for the petitioner. Also heard Ms. Linda L. Farmwell, Ms. Vannesyami, Learned Additional Public Prosecutor, appearing for the state of Mizoram. This criminal petition has been registered on filing of an application under section 483 within bracket 3 of BNSS, read with section 528 of the said Sanhita by the petitioner, namely Mahindra and Mahindra Financial Services Limited, impugning the order dated 22/5/2025 passed by the Court of Learned Chief Judicial Magistrate, passed by the Court of Learned Judicial Magistrate First Class number 3 Aizawl in bail application number 287/2025, whereby the respondent number 2 was granted bail in connection with Aizawl PS case number 96/2024. Stop. Issue notice to the respondents. Since Ms. Vannesyami has appeared for respondent number 1, no formal notice need to be sent to respondent number 1. Stop. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 8th of August 2025. List this matter again on 8th of August.
Admission, item 2.
Yes.
May I please, Your Honor? Your Honor, the petitioners are working as principals of higher secondary school.
Miss Vannesyami, you are ready?
Yes, sir.
Okay. Yes, Mr. Malhotra.
May I please, Your Honor? The petitioners are altogether 18 in number, and they are presently working as principals of higher secondary schools under the respondents.
Yes.
And Your Worship, the grievance of the petitioners, Your Worship, is that the principals of middle school and high school under the government of Mizoram are all being paid a 3-tier grade pay scale. 3-tier grade pay system is being enjoyed by the principals of middle schools and high schools. That means once the high school principal or a middle school principal is promoted to the post of principal, there's an entry grade. Thereafter, your lordship will see, if I take your lordship to page 35. Annexure 5, page 35.
Yes,
If I may read this, Your Honor.
yes.
In exercise of the powers conferred by proviso to Article 309, read with Article 162 of the Constitution of India, and on the basis of the decision against item number 5 of the Council of Ministers in its meeting held on 14th of December 2015, the Governor of Mizoram is pleased to order introduction of 3-tier grade pay in respect of Headmaster High School and Middle School under School Education Department with immediate effect. The double increment granted by government notification so-and-so dated 4/7/2012 in respect of middle school headmasters stands abolished with immediate effect, and the double increment already received by the existing headmasters of middle school shall not be recovered from their salary, but to be considered as advance increments and shall be absorbed in future increments. The 3-tier grade pay of headmaster middle school and high school under school education are shown in the table below. So for the headmaster, if your lordship will see, there's the entry grade where
Senior grade.
the headmaster enjoys PB3 with grade pay of 5,400, which is under the 6th ROP 2010. So under the new grade pay, it remains the same. Now there's a senior grade. Senior grade, early on there was no senior grade, but now as per the decision of the Council of Ministers by this notification dated 25th January 2016, senior grade of grade pay of 6,100 has been introduced. Then there's a selection grade, where the selection grade is pay band 3 and grade pay of 6,600. So this is the 3-tier system of pay which has been introduced for the headmasters of high schools. In similar manner, you also will see serial number 2, 3-tier grade pay system has also been introduced for the headmasters of middle school.
Middle school.
Entry grade is PB3, grade pay of 4,800, senior PB3, grade pay of 5,400, selection grade, pay band 3 of grade pay 6,100. And the residency period is as follows. Senior grade, 8 years regular service in the entry grade as headmaster shall be eligible for senior grade. And selection grade, 16 years regular service in the entry grade as headmaster shall be eligible for selection grade. So this is the system which is being enjoyed by the headmasters of middle school and high schools. Whereas the principals of the higher secondary schools, we are not enjoying any 3-tier grade pay system. And why this 3-tier grade pay system has been introduced in respect of the middle school and high school headmasters, if I may take your lordship to the reasoning given by the state respondents. In fact, if I may take your lordship to page 23, annexure 4.
Yes.
Page 23, annexure 4 is the reply given to the council, one of the councils for the petitioners through the RTI. And your lordship will see the copy of serial number 2, copy of cabinet memorandum of agenda number 5 regarding 3-tier grade pay of high school headmasters and middle school headmasters under school education department, considered in the meeting of Council of Ministers held on 14th December 2015. So the high school and middle school headmasters have submitted representation to the government requesting for 3-tier grade pay, which is at page 21 is the representation submitted by them. This is the representation submitted by the Middle School Teachers Association praying for 3-tier grade pay, which is in Mizo, Annexure 3, page 21, and the English translation is at page 22. So before going into the memorandum, if I may take your lordship through the representation submitted by the Middle School Teachers Association.
Yes.
This is addressed to the Honorable Education Minister dated 12th of May 2015. Subject regarding 3-tier grade pay of government middle school headmaster. So we sincerely request you to grant us our wishes in the name of Middle School Teachers Association, MSTA. Amongst the teaching staff at School Education Department, only we, the middle school headmasters and work education teachers are not granted 3-tier grade pay. Our representation in this regard was considered in the Mizoram Finance Department officer meeting held on 5th of May 2015. Our request is grade pay entry 4,800, senior 5,400, selection 6,100. When the Mizoram Education Service was being prepared and the pay of academic and administration was considered, grade pay 5,400, senior 6,100 and selection 6,600 was prepared for the pay of government middle school headmaster. We are under the impression that this was rejected by the finance department. Unfortunately, the matter was not included as a meeting agenda at the recent finance department officers meeting. Comparing it with our former request, it was considered a dual proposal, and not knowing which proposal should be approved, the matter was left to be discussed on a later occasion. MSTA is still standing with our representation for 3-tier system, that is grade pay entry 4,800, senior 5,400, selection 6,100, which is also the standing proposal of our department, that is School Education Department. If you kindly grant us our request, we are willing to surrender the double increment wide notification dated 4/7/2012 granted to us. While considering this matter, grant of 3-tier grade pay to the WE teachers, work education teachers, was approved and is only awaiting approval of the cabinet meeting. We want our matter to be considered by the cabinet along with the case of the work WE teachers. Therefore, we sincerely request you to take necessary action to fulfill our request. So there was a representation from the Middle School Teachers Association requesting that they should also be granted the 3-tier grade pay system. And this matter was taken up by the Council of Ministers in its meeting held on 14th of December 2015, Your Worship. And page 25 is the memorandum for consideration of Council of Ministers, which was submitted by the Finance Department. Page 25, Your Honor. And this makes very interesting reading. Why the Finance Department had recommended for 3-tier grade pay system for the high school and middle school headmasters. If I may read this, Your Honor.
Yes.
Subject 3-tier grade pay of high school headmasters and middle school headmasters under School Education Department. Pay upgradation of Mizoram Government Employees 2012 was notified / implemented with effect from 1st of June 2012 for the employees under the Government of Mizoram in accordance with Pay Committee 2011 White Notification number so-and-so dated 4th of July 2012. Middle school headmasters. Headmasters under School Education Department were, middle school headmasters under School Education Department were granted double increment in the pay upgradation of Mizoram Government Employees 2012, while headmasters of high school were not granted. And teachers were granted 3-tier grade pay in the pay upgradation of Government Employees 2012. Due to absence of 3-tier system, there are some headmasters who have served more than 20 years but still enjoyed the grade / pay scale of selection grade teachers. The Middle School Teacher Association submitted representation for granting 3-tier grade pay to headmasters and also agreed that the double increment already granted would be surrendered if 3-tier grade pay are granted. Hence, this is very interesting, Your Worship. Hence, proposal is submitted to maintain uniformity in the pay structure and also to be part of an incentive to headmaster. So, this is the reasoning of the finance department. Proposal is submitted to maintain uniformity in pay structure and also to be part of an incentive to headmaster. The pay and allowances with the demand of middle school headmaster under school education department as shown below. So, entry grade remains the same. Senior grade, Your Worship, there was no senior grade, but now the proposed pay is there. It is a new grade to be introduced. Selection grade remains the same. The double increment so granted and already received by the existing headmasters should not be recovered from their salary, but to be considered as advance increments and should be absorbed in future increment. Pay and allowances with the demand of high school headmaster under school education department are shown below. So the main reason why the finance department recommended the 3-tier grade pay system for middle school and high school headmasters is at page 25. The proposal is submitted to maintain uniformity in pay structure and to be part of an incentive to headmaster. So now, if I take Your Lordship to page 24, the memorandum was approved by the Council of Ministers. Page 24, this is the extract of minutes of meeting of Council of Ministers held in the conference hall, Chief Minister's office on 14 December 2015. Agenda number 10, 3-tier grade pay of high school headmasters and middle school headmasters under school education department. This was submitted by the finance department. Approved on the condition that double increment so granted to the middle school headmaster shall be withdrawn or abolished. The double increment so granted and already received by the existing headmasters should not be recovered from their salary, but to be considered as an advance increment and should be absorbed in future increment. So, the only reason, Your Worship, the finance department recommended 3-tier grade pay system on behalf of middle school and high school headmasters is to maintain uniformity in pay structure and also to be part of an incentive of headmaster. Because, Your Worship, all the teachers under the school education department are being paid 3-tier grade pay system.
Okay.
Now, if I may take Your Lordship to page 29.
Yes.
This is the statement of objects in the memorandum which was submitted by the finance department. This is a part of the memorandum, statement of objects. If I may read this, Your Honor. With the implementation of Pay Committee 2011, there were several factions of employees profoundly aggrieved at the revised pay structure to which their pay should be fixed, and the headmaster of middle school and high school who were placed uniformity among the employees under school education department due to upgradation of 3-tier grade pay with teachers. Pay upgradation 2012 granted 3-tier grade pay for teachers, while high school headmaster and middle school headmaster were not granted 3-tier grade pay. Double increment were granted for middle school headmaster. High school headmaster were not granted even double increment. They enjoyed 6th Central Revision of Pay as modified and extended to the employees under Government of Mizoram, Rules 2010, 6th ROP. The absence of 3-tier pay system in the case of headmasters creates problems in administration schools, even in departmental level. Many senior teachers decline promotion due to absence of service benefits. Introduction of senior grade will guarantee service benefits / financial benefits after 8 years regular service in the headmasters. It is expected that the rate of declining of promotion will be reduced considerably. Hence, if 3-tier grade pay is so granted, Middle School Teachers Association agrees to surrender double increment that has already been granted. Moreover, uniformity will be there among employees under school education. So, again, it has been stressed that there will be uniformity amongst the employees under the school education department. uniformity in the sense that all teachers, headmasters, etc. will be enjoying 3-tier grade pay system. And at page 25, the memorandum says that it will also be part of an incentive to headmaster. So accordingly, Your Worship, once the present petitioners had also come to learn, and then page 35, Annexure 5 is the notification implementing the decision of the Council of Ministers.
With regard to high school and middle school.
Middle school, 3-tier grade pay system. In exercise of powers conferred by proviso to Article 309, read with Article 162 of the Constitution of India, and on basis of decision against item number 5 of Council of Ministers in its meeting held on 14 December 2015. So it was implemented by way of this notification. 3-tier grade pay system was introduced for high school and middle school headmasters. Thereafter, Your Worship, the petitioners, being aggrieved by the action of the respondents in not granting them the 3-tier grade pay system, they had submitted 2 representations. Page 36 is the first representation. The English translation is at page 38. If I may read this, Your Honor.
Page 37.
Yes, 36 is the representation which is in the local vernacular. Page 37 is the English translation.
Yes.
This is the first representation.
Yes.
If I may read, Your Honor. Page 37 is the English translation.
Yes.
To the Secretary, Government of Mizoram, Finance Department, Government of Mizoram, subject request for grant of 3-tier to the Principal Government Higher Secondary School. We kindly request you to consider and grant us our wishes. The Government of Mizoram had given benefits in a number of ways to the teaching staff in the past, and after knowing that double increment and 3-tier grade were recently granted to the head of institution at different stage of school, we request you to grant the same to the Principal of Government Higher Secondary School, and the reasons as to why we may be granted such benefits are as follows. Number 1, with regards to duties and responsibilities, etc. Keeping in view the past, since the duties and responsibilities of the principal is more extensive than other head of institution, that is primary, middle and high school headmasters, we are also appointed as head of office and drawing and disbursing officer till date. Apart from financial power, we are also assigned a number of different works under the establishment. Conduct of examinations. We are entrusted with huge responsibility and other important tasks by the central and state government, which were not assigned to other stage of school, that is primary, middle and high school, such as conducting examination of UPSC, staff selection, NIOS, MPSC, and other departmental examination. Some of these examinations are conducted on holidays, Saturday and Sunday. Staff and student strength. With regard to staff and student strength, since we, Government Higher Secondary School, managed all the establishment of high school staff, we look after 30 to 120 staff and 500 to 1200 students in most of the schools. Double increment of primary and middle school headmaster. As mentioned above, while we higher secondary school principals are entrusted with huge responsibilities, primary and middle school headmaster were granted double increment in lieu of special allowances, that is 6% increment with effect from 1st of May 2012. As stated above, high school headmaster were also granted double increment as that of primary and middle school headmaster. C. Middle and high school headmaster were granted 3-tier of grade pay, entry grade, senior and selection grade recently. We kindly request you to consider our situation and grant us 3-tier of grade pay as that of our colleagues headmaster. So this was the first representation submitted, Your Worship. Then another representation was submitted, which is at Annexure 7. The English translation is at page 39. The first representation was submitted in 2018. Your Honor. The second was submitted in 2022. If I may read page 39,
Yes.
the second representation.
Yes.
This is to the secretary, to the principal secretary, finance department, subject request for 3-tier system for the pay of principal, government higher secondary school. Sir, greetings in the name of government higher secondary school principal council of Mizoram. Representation regarding the pay of government higher secondary school principal has been submitted since the year 2018. However, the matter has not been considered till today. In the meantime, our colleagues in elementary and secondary school headmaster under school education have been granted double increment and 3-tier system. Therefore, the principal council meeting expect the government to grant us the same pay system granted to our colleagues under school education department. And we believe that our claim is appropriate. We request your authority to consider our request at the earliest possible. We request you to make our pay as per details given in the table below. So this is the 3-tier pay scale which was requested by suggested by the principal council. They call themselves principal council. But however, Your Worship,
What happened to this?
it was rejected. Which
Rejection order is there.
page 40. Next page. Your Worship.
Yes.
Which annexure 8 is the rejection.
Yes.
I'll read this, Your Worship, page 40. Minute of meeting held in the office chamber of Pu Walal Swang of Principal Secretary, Finance Department on 25th of May 2022 to discuss representation submitted by Principal Council, Government Higher Secondary School regarding grant of 3-tier system to Higher Secondary School Principal. The meeting was chaired by Pu Walal Swang, Principal Secretary, Finance Department. Following officers attended the meeting. 6 names are given. The chairman invited Pu Si Lung Muan Puya, Under Secretary, to briefly apprise the members of the agenda. As invited, he stated that the Principal Council, Government Higher Secondary School, submitted representation to the Principal Secretary, Finance Department to grant 3-tier system, namely Principal Entry Scale, Principal Senior Scale, and Principal Selection Scale, as per details given in the table below. These are the 3 grades which were demanded by the Principal Council. In their representation, they state that they are expecting and wanting 3-tier grade of middle school and high school headmasters. However, the case of middle school and high school headmasters are different from the case of higher secondary school principals. The reason for which 3-tier grades were granted to middle school headmasters and high school headmasters are as below. Next page, Your Worship. Number 1, pay of selection grade middle school teacher is PB2, pay band 2, rupees 9,300 to 34,800 plus 5,400 grade pay. While pay of middle headmaster entry scale is PB2 9,300-34,800 plus 4,800 GP, which is lower than selection grade teacher. Hence, for administrative convenience, it is imperative to introduce 3-tier system, that is headmaster entry PB2 plus 400 GP, headmaster senior PB2 plus 5,400 GP, and headmaster selection PB2 plus 6,100. Pay of selection grade high school teacher is PB2 9,300 to 34,800 plus 5,400 grade pay, which is the same as pay of high school headmaster entry scale. Hence, it is also imperative to introduce 3-tier grade to headmaster of high school for administrative purpose. Meantime, pay of higher secondary school lecturer are lecturer entry PB3 15,600 to 39,100 plus 5,400 grade pay, lecturer senior PB3 15,600 39,100 plus 6,100 GP, and lecturer selection PB3 15,600 to 39,100 plus 6,600 grade pay, while pay of principal higher secondary school is PB3 rupees 15,600 to 39,100 plus 7,100 grade pay, which is still higher than pay of selection grade lecturer, which shows that the question of administrative inconvenience as faced by middle school headmaster and high school headmaster does not arise. Hence, in view of the points mentioned above, the meeting opined proposal for grant of 3-tier grade to principals of government higher secondary schools is found not feasible.
What administrative inconvenience they are indicating?
According to their explanation here, they say that the pay of a selection grade middle school teacher, selection, if you also will see page 41, the serial number 1, the pay of selection grade middle school teacher is pay band 2, 9,300 to 34,800 plus 5,004 grade pay, while pay of middle school headmaster entry scale is PB 2, 9,300 plus 34,800 grade pay of 4,800. So they are trying to say that the pay of the middle school headmaster is lower than the pay of selection grade middle school teacher. And so their administrative inconvenience. Similar manner, the pay of the high school headmaster is equivalent to the pay of selection grade high school teacher. Serial number 2. So that is why they are saying that the pay, the 3-tier grade pay system was introduced.
So that the headmaster's pay remains more than the teacher's pay.
Yeah, equivalent. But if I may take a lordship to the memorandum which was submitted by the finance department to the Council of Ministers, recommending 3-tier grade pay for headmasters of middle school and high school.
This reason was not mentioned.
The reason here at page 25, if your lordship will go back, kindly go back to page 25.
The reason was uniformity and incentive.
Uniformity in pay structure, meaning 3-tier pay system will be enjoyed by all teachers working under education department, and also to be part of an incentive to headmaster. Page 25, Your Worship. The last sentence of para 1.
Yes.
Last sentence of para number 1. Hence, the proposal is submitted to maintain uniformity in pay structure and also to be part of an incentive to the headmaster. So, now the reason for rejecting our representation is totally different from the reason why they had recommended 3-tier pay structure for high school and middle school headmasters. Totally different. So, Your Worship, in fact, all the teachers working under education department are being given 3-tier pay system. And if Your Lordship will kindly go to my reply affidavit, I have submitted a reply affidavit. In my reply affidavit also,
Just yes. Yes.
You also will see at page 6.
Yes.
This is again 10th of February 2023, notification issued by the Finance Department. In pursuance of the decision of the Council of Ministers in its meeting held on 27th January 2023, in respect of agenda number 5, 3-tier grade pay is hereby granted to Vocation Education Teacher under School Education Department with effect from 1st February 2023. Again, 3-tier pay structure has been granted to vocational education teachers, entry grade, senior grade, selection grade. And in pursuance of the decision of Council of Ministers in its meeting held on 27 January 2023, and Your Worship, we had acquired the memorandum which was submitted by the department, Finance Department, to the Council of Ministers by way of RTI, which is at page 7.
Yes.
So this is the memorandum page. It starts from page 8. Memorandum which was submitted by the Finance Department. Proposal for introduction of 3-tier grade pay of vocational education teacher under School Education Department. And if I may take a lordship to page 16.
Yes.
Justification, page 16. Justification. Teaching community under School Education Department are not covered by Modified Assured Career Progression Scheme and Time-Bound Promotion Scheme. As such, teachers and WE teachers were given 3-tier grade system for non-functional promotion. Meantime, vocational teachers have no financial benefits schemes like MSCPS, Time-Bound Promotion Scheme TBPS, or non-functional pay upgradation of senior selection grade pay. DPNAR, ARWF also advised that since vocational teachers belong to teaching community, non-functional promotion may be granted to them as enjoyed by teachers under School Education Department. Hence, creation of 3-tier grade system for non-functional promotion of vocational teachers proposed. So, Your Worship, we are also under the Education Department. I mean, there's no reason not to give us this 3-tier grade pay. Here they're saying that teaching community under School Education Department are all given 3-tier grade pay.
You also are member of teaching community.
Yes, Your Worship. And like they said, to bring uniformity into the pay structure and to be an incentive. The grade pay, whatever they formulate, we'll be happy with that. But that same system.
Now, what incentive do you have?
Nothing, Your Worship.
Only the increment.
Only the entry grade.
Entry grade and the yearly increment.
Yes, that is in their affidavit, Your Worship. The state have given a table. And in fact, Your Worship, initially, because the grade pay of the middle school headmaster was lower than the selection grade teachers' pay, the Council of Ministers had issued an order giving them double increment.
To middle school.
Middle school headmasters. Because if your Lordship will see,
No, but that they have now
they withdrawn.
waived off.
They withdrew. But initially, to remove the anomaly, they had given them 2 increments at the time of promotion. But now, since introducing this 3-tier grade pay system, that has been withdrawn. It is mentioned in the order, Your Worship, at page 35 of the writ petition. Anyway, if I take Your Lordship to the affidavit filed by the state in para 4,
Yes.
with regard to statements made in para 7 and 8 of the writ petition, I say that it may be mentioned that same pay band and grade pay was enjoyed by middle school teacher and headmaster 6% double increment. So same pay band and grade pay was enjoyed by middle school teacher and headmaster. So the anomaly was removed by giving the headmaster 6% double increment. Before, 3-tier grade pay was given to middle school headmaster. This restructuring of middle school headmaster grade pay in the form of 3-tier pay greatly solved the internal administrative problems of the department. The existing pay structure of middle school and high school are as below. Now, this is the table prepared by them, Your Worship. Serial number 1 is middle school headmaster. He is getting the entry pay of 4,800. Then senior, after 8 years of service, they are being given senior grade pay 5,400 in level 10. Then selection grade 6,100 in level 11. So middle school teachers, they are getting 4,600 in level 8. Then again, they are getting senior grade level 9, and they are also getting selection grade level 10. 5,000. Even high school headmaster is being given 3-tier grade pay. High school teacher is also being given 3-tier grade pay. Lecturers of higher secondary school serial number 7 also being given 3-tier grade pays, but only the principals of higher secondary schools are given only one level of grade, the entry grade. So we have no incentive. We have no senior grade pay, we have no selection grade pay. So that is where the discrimination comes in, Your Worship.
And their main ground for denying it is that the lecturer of higher secondary school, even if he is given selection grade, he gets lesser pay than what you are getting now.
They're saying, Your Worship, if Your Lordship will see, if I take Your Lordship to the rejection at
page 40.
Page 40. Serial number 2, Your Worship. Pay of selection grade high school teacher is PB2 5,400 GP, which is same as pay of high school headmaster entry scale. Okay, well and good. If I may take Your Lordship to this additional affidavit filed by the state, serial number 3 and 4. If Your Lordship will kindly see page 3 of the affidavit filed by the state, para 4. Affidavit filed by the state.
Yes.
Has Your Lordship got it?
Yes.
Serial number 3 and 4. I'll take Your Lordship to the serial number 4, high school teacher. High school teacher, okay, entry is 4,600 level 8, senior grade is 4,800 level 9, and selection grade is level 10 5,400, which is equivalent to the entry pay of the headmaster high school. But then he's getting two incentives, two increments. After 8 years, he's going up to 6,100, and after 16 years, he's going up to 6,600. Meaning, even if at the time of entry,
it may be same, but
then after 8 years, he's getting one increment.
So he'll be getting higher salary.
Yes, and here we are stuck in the same pay. So that means even if the entry pay level of high school teacher in selection grade and headmaster high school in the entry grade is similar, but then the headmaster carries on, he gets 2 increments.
Are you given any incentive like double increment?
Nothing.
No. So for you there is no incentive.
No incentive, nothing. So that is why now The high school headmasters and middle school headmasters were given 3-tier grade pay to maintain uniformity and as incentive. Now, why don't they apply that same principle to us?
Okay.
To maintain the uniformity in the pay structure and to give us some incentive. That is the grievance of the petitioners. They have tried to explain that there is no administrative inconvenience in the case of higher secondary school principals because their pay is higher than the higher secondary teachers' selection grade pay. But that is not the case. It's not regarding anomaly. Here we are not concerned with. We are concerned with the 3-tier grade pay system which has been given to the middle school and high school teachers to maintain uniformity as an incentive, which is missing in
parity. You are seeking parity
Yes.
with members, other members of teaching community.
Under the same government, school education department. So that is the case of the petitions.
And not doing so is violative of Article 14.
And 16.
Okay.
And
You are relying on any authority?
Your Lordship, I'll take out one, Your Lordship, but let my learned friend answer, then I'll take Your Lordship to the.
Okay.
But that is why, I mean, if the pay of the selection grade teacher in the high school is equivalent to the entry pay of high school headmaster, there's a pay anomaly which can be corrected by them, which has also been corrected in the case of middle school teachers by giving them double increment. So I mean, we are not on that. We are on the fact that 3-tier grade pay system is being enjoyed by our counterparts in middle school and high school headmasters. Give us the same incentive, give us the same uniformity in pay structure. That is what is our grievance.
You are deprived of either incentive or and also uniformity.
In pay structure.
Basically.
Here we are stuck in the entry level once we are promoted. It is very clear from the table, Your Lordship, at paragraph 4 of the affidavit.
Yes, Ms. Vannesyami.
Yes, Your Lordship. The reason for reconstructing the pay of the middle school headmasters as well as the high school headmasters into 3 tiers pay band was well explained. The reason they have proposed that 3 tiers pay band. And my Lord, regarding the submission made by the Learned Council regarding that incentive, in the whole representation they have submitted. They have submitted 2 representation, and in that representation by the petitioner, they did not mention about the incentive. The representation was wholly for 3-tier grant pay, my Lord. So if they want to twist the prayer, they should approach the authority by submitting the representation regarding that incentive. Now, in the present hand, my Lord, in this particular case, this is only regarding the 3-tier grant pay. And the reason why they propose the 3-tier grant pay to the middle school headmaster as well as the high school headmaster is that there is not uniformity in the pay scale, and also there is some internal administrative problems. And without having financial benefits, my Lord, there is lots of declination into promotion, which the government had faced so many administrative problems. And now, after introducing this 3-tier pay band, the declination of that promotion was also solved because there is uniformity in their pay. So, my Lord, with regard, I would like to take you to page number 3 of my affidavit in opposition, my Lord. Page number 3, para number 4. This is the existing pay structure after imposing this 3-tier grade pay. So, my Lord, here we can see that the principal higher secondary school is getting higher pay, and for them, for the lecturer high school, they are getting 6,600, and when they promoted to the principal, they enjoy the benefits, financial benefits. And before imposing this 3-tier grade pay to the middle school headmaster as well as the high school headmaster, they did not enjoy these financial benefits. Only after imposing this 3-tier grade pay only, they enjoyed these financial benefits. So, my lord, the government has imposed this 3-tier grade pay for the middle school, high school, the headmaster as well as the high
What is
school.
the qualification for a higher secondary principal? To be a principal of higher secondary school.
You have the recruitment rules are there. If your lordship will kindly allow me to take your lordship to the recruitment rules.
At what age he may enter into the service? Or whether he has to be any eligibility, what is the eligibility criteria?
Eligibility criteria, your lordship, is, if I may take your lordship to page 16,
Page 16 of the writ
writ
petition.
petition. The annexure 1 is the recruitment rules of the Principal Government Higher Secondary School 2017,
Yes.
and eligibility criteria will be column 12. Promotion from lecturer Government Higher Secondary School on regular basis in selection grade, having Bachelor of Education, failing which from lecturer Government Higher Secondary School in senior grade, having Bachelor of Education with 5 years regular service. So, but this was amended in 2021. Column
So it is a promotional post.
and column 12 has been amended in 2021, page 20, annexure 2. Has your lordship got it? Page 20, annexure 2. This is the Mizoram School Education Department Group A Post Recruitment Amendment Rules of 2021 and amendment of column 12, bottom of the page. Promotion from selection grade lecturer, Government Higher Secondary School with at least 3 years regular service in the grade. So, early on, 50% by promotion, 50% by limited departmental examination. But since 2021, it is 100% promotion from selection grade lecturer, Government Higher Secondary School with 3 years regular service.
Then is it whether these posts are similar to that of a principal of middle school, headmaster of a middle school and headmaster of
Yeah, Your Worship.
high school?
Similar in the sense of
Similar, what is the eligibility criteria of to be a headmaster of a middle school?
again,
Whether those posts are also promotional posts
those are all promotional courses.
or direct entry is
Your Worship, there's no direct entry. It's all promotional course, Your Worship.
Because when you seek parity,
Yes.
you have to show that you stand in same footing. And
I have the rules, Judge. For high school headmaster,
what it says,
75% promotion, 25% limited departmental examination.
promotion from
Promotion from
limited departmental, that means it is also a promotional post.
yeah. It is promotion.
Can it be looked into in this way? Where government is wrong, whether government is wrong if government says, though they have not stated so, that the principal of higher secondary school is itself a promotional post to a person who is already a selection grade
Teacher
teacher.
in the higher secondary school.
So his appointment to the post of principal is itself an incentive. So further incentive is not required.
Judge, but even the post of principal headmaster of high school and middle school is also promotion post.
Okay. How long a person remains as, at what age, what is the age criteria is there?
There is no age criteria.
Minimum age criteria is not there.
Judge, according to these recruitment rules, 2021, the entry grade of headmaster government high school is 75% promotion, 25% LDE. Senior grade is 100% promotion, and selection grade is also 100% promotion.
And principal, headmaster,
No, Your Worship, headmaster of high school, they have three grades: entry grade, selection grade, senior grade, and selection grade.
in entry grade, 75% by promotion and 25% by limited departmental examination.
Yes. Senior grade, 100% promotion. Selection grade, 100% promotion.
Now, Ms. Vanesami, how the headmaster of a higher secondary school is different from headmaster of a middle school and high school, so as to justify a differential treatment by government by not giving 3 scale?
Yes, Your Lordship. The difference is that, at the entry level,
They get a higher salary.
no, my lord, at entry level, the pay band which they have created before 3 tiers grade pay, they have already enjoyed these facilities by the government higher secondary school, my lord, which was not enjoyed by the middle school headmaster as well as the high school headmaster.
Yes.
So, in order to make the uniformity in their pay band, this 3-tier grade pay was imposed.
Yes, that you have stated in your reply.
Yes, Your Lordship.
Where?
In para number 4, my lord.
Para number?
4. If I may read out.
Yes.
That with regard to the statement made in paragraph number 7 and 8 of the writ petition, I say that it may be mentioned that same pay band and grade pay was enjoyed by middle school teacher and headmaster, that is 6% double increment before 3-tier grade pay was given to middle school headmasters. This restructuring of middle school headmaster grade pay in the form of 3-tier pay greatly solved the internal administrative problems of the department.
No, then one more query. In your rejection letter at page 40 of the writ petition,
Yes.
you took a different stand, but in the cabinet memorandum, you have stated different reasons for. In cabinet memorandum, you have stated the reasons for giving 3-tier pay scale to the middle school and high school principal as uniformity of pay structure and providing incentive to them. But while rejecting their representation, you have mentioned a different reason, that in administrative inconvenience due to. What is your explanation to that?
No, my lord, even in the rejection letter, that is in page 12 of my affidavit, in para number 3.
Page?
Page number 12. Yeah, I know.
Yes. Yes.
In para number 3, my lord. Meantime, pay of higher secondary school lecturer and entry payment 3 rupees so and so, while pay of principal higher secondary so and so, which is still higher than pay of selection grade lecturer, which shows that the question of administrative inconvenience as faced by middle school headmaster and high school headmaster does not arise. So, my lord, here it is mentioning clearly that administrative problems does not arise.
No, which para you are reading?
Para number 3.
Para 3
Yes.
in page?
Page number 12 of my affidavit in opposition.
Your Worship, it is similar to page 41, para 3.
Just a minute. Yes.
Similar to page 41, para 3.
No, but this you have not stated in the cabinet memorandum.
In the cabinet memorandum, it is stated that there is administrative problems, and mentioning that the headmaster of the higher secondary school already enjoy the benefits, financial benefits, being promoted to headmaster, principal. So, my lord, even though the sentence and the words which are using are exactly not similar, but the intention of the government, it can be clear that the reason why they have imposed 3-tier grade pay for the middle school headmaster as well as the high school headmaster, their intention is very clear in order to solve the administrative problems. As well as the financial benefits which was not enjoyed before. In order to solve the problems, this 3-tier grant pay was imposed.
Okay. Yes, anything else?
Yes, in addition to my submission, I would like to rely on 3 citations, 3 authorities. (2022) 4 SCC 193, State of Maharashtra and other versus Bhagwan and others.
2022 4 SCC, page number.
Page number 204. From
In citation
193.
193. What is the relevant para?
Para 28, which is in page number 204.
Is what it says.
As per the settled proposition of law, the court should refrain from interfering with the policy decision which might have a cascading effect and having financial implications. Whether to grant certain benefits to the employees or not should be left to the expert body and undertakings, and the court cannot interfere lightly. Granting of certain benefits may result in a cascading effects having adverse financial consequences. And Your Lordship, another citation will be 2021 8 SCC 784.
2021
8
is
SCC 784.
784. Yes.
Page number 785.
Para
Para 43.
43. Yes. What it says.
The power of judicial review over the administrative decision of the state was examined by a judgment of this court in Tata Circular versus Union of India. Though that is a case of grant of contract, but the principle of law are very well applicable to the exercise of power of judicial review by the High Court in the administrative decision of the state within the meaning of Article 12 of the Constitution. The court held as under. The duty of the court is to confine itself to the questions of legality. Its concerns should be whether a decision-making authority exceeded its powers. Number 2, committed an error of law. Number 3, committed a breach of the rules of natural justice. Number 4, reached a decision which no reasonable tribunal would have reached. Or number 5, abused its powers. Therefore, it is not for the court to determine whether a particular policy or particular decision taken in the fulfillment of that policy is fair. It is only concerned with the matter in which those decisions have been taken. The extent of the duty to act fairly will vary from case to case.
Okay.
And my third citation will be 2023 SCC Online SC 173. Para 12.
Yes.
Para 12, I will rely on sub-para number 19. Undoubtedly, the doctrine of equal pay for equal work is not an abstract doctrine and is capable of being enforced in a court of law. But equal pay must be for equal work of equal value. The principle of equal pay for equal work has no mechanical application in every case. Article 14 permits reasonable classification based on qualities of characteristic of persons recruited and grouped together, as against those who were left out. Of course, the quality or characteristic must have a reasonable relation to the object sought to be achieved. In service matters, merit or experience can be a proper basis for classification for the purposes of pay in order to promote efficiency in administration. A higher pay scale to avoid stagnation or resultant frustration for lack of promotional avenues is also an acceptable reason for pay differentiation. And my note, I will not read out the whole para. I will jump to the last portion. The next page, that is from 8th line, from the 8th line. Same para, 8th line. Last 8th line.
Yes.
In any event, from that part, my lord. In any event, the party who claims equal pay for equal work has to make necessary avertments and prove that all things are equal. Thus, therefore, any discretion can be issued by a court. The court must first see that there are necessary avertments and there is a proof. If the High Court is, on basis of material placed before it, convinced that there was equal work of equal quality and all other relevant factors are fulfilled, it may direct payment of equal pay for the date of the filing of the respective writ petition. In all these cases, we find that the High Court has blindly proceeded on the basis on the doctrine of equal pay. And my lord, again on para number 14, para 14.
Yes.
In view of the above stated legal position, it is clear emerges that though the doctrine equal pay for equal work is not an abstract doctrine and is capable of being enforced in a court of law, the equal pay must be for equal work of equal value. The equation of post and determination of pay scales in the primary function of the executive and not of the judiciary. The courts therefore should not enter upon the task of job evaluation, which is generally left to the expert bodies like the pay commissions, which undertake rigorous exercise for job evaluation. After taking into consideration several factors like the nature of work, the duties, accountability, and responsibilities attached to the post, the extent of powers conferred on the persons holding a particular post, the promotional avenues, the statutory rules governing the condition of service, the horizontal and vertical relatives with similar jobs, etc. It may be true that the nature of work involved in two posts may sometimes appear to be more or less similar. However, if the classification of post and determination of pay scale have reasonable nexus with the objective or purpose sought to be achieved, namely the efficiency in the administration, the pay commission should be justified in recommending and the state should be justified in prescribing different pay scale for the seemingly similar post. A higher pay scale to avoid stagnation or resultant frustration for lack of promotional avenues or frustration due to longer duration of promotional avenues is also an acceptable reason for pay differentiation. It is also a well-accepted position that there would be more than one grade in a particular service. The classification of post and the determination of pay structure thus falls within the exclusive domain of the executive, and the courts or tribunal cannot sit in appeal over the wisdom of the executive in prescribing certain pay structure and grade in a particular service. And my note, one last paragraph, that is in paragraph number 17.
Yes.
The power of judicial review in the matters involving financial implication are also very limited. the wisdom and advisability of the courts in the matters concerning the finance are ordinarily not amendable to judicial review unless a gross case of arbitrariness or unfairness is established by the aggrieved party. With that one, Your Lordship, I will conclude my objection.
I'll point out the arbitrariness from their affidavit. If I may take a Lordship again to para 4 of the affidavit filed by them, just to point out the arbitrariness, where they say that administrative inconvenience, the table,
Yes.
if Your Lordship will see the table in paragraph 4, serial number 5 and 6, the pay of selection grade lecturer of higher secondary school, which is in serial number 6. The pay of selection grade of lecturer of higher secondary school is level 11, 6,600. If Your Lordship will see.
Yes.
Then serial number 5, the principal of higher secondary school entry pay is admittedly higher by the lecturer higher secondary school selection grade pay.
Yes.
Now admitted. Now if I may take Your Lordship to serial number 4,
Yes.
high school teacher, last column, selection grade lecturer, selection grade teacher of the high school gets level 10. And the serial number 3, the entry pay of high school headmaster is also level 10, so they're equivalent.
Yes.
But then he gets senior grade level 10A, which is 6,100. This, we can say that it is comparable to the entry pay of the principal higher secondary school. But then, what about the selection grade level 11 pay, which is paid to the headmaster, 6,600? He is getting 2 increments. I mean, one after 8 years, one after 16 years. The level 10A, which he gets after 8 years, brings him into equal status with the principal of higher secondary school. Entry grade.
No, he's still lesser than principal.
Yes. No, what I'm trying to say, it is lesser, but the structure, they're getting 3 tier grade pay. I'm not saying that the pay should be equal. I'm saying that 3 tier grade pay system.
No, to get the same incentive and same pay structure, you have to, or to claim same treatment
Yes.
from the government, you have to first satisfy that you fall within the same class.
Yes.
You cannot be treated differently.
Different.
But your entry level pay is much higher than even selection grade headmaster of a middle school or selection grade headmaster of a high school.
Yes, that is because your higher secondary school is 10 plus 2. We are teaching class 11 and 12. Headmasters are teaching class 9 and 10, high school. Middle school is classes 5 to 8. So that's where the differentiation comes in. We are teaching class 11 and 12 students. The only grievance is that while the headmasters of middle school and high school are given 3 tier grade pays, we have no incentive. Once we are promoted, we are stuck in that entry pay for the rest of our career till our retirement. But this 3 tier grade pay has been allowed to be enjoyed by the high school and middle school headmasters to maintain uniformity and give them incentive. Why aren't they giving us also incentive? Aren't we also entitled to incentive from the government? We are also working under the same government, under the same department. If they are going to give incentive to the other principals of high school and middle school, aren't the principals of higher secondary schools also entitled to some incentive? That is the grievance of the petitioners here.
But the post of higher secondary
It's
Principal
a higher level because we
is
are,
itself an incentive. The post to be appointed as principal of higher secondary school is in itself an incentive to a lecturer of, because before being appointed you have to be a
so
lecturer
that
of
is,
selection grade for at
that
least
is why
3
your
years.
that is why if your lordship will see para 3 and serial number 3 and 4 again.
Yes.
High school teacher selection grade. So when he becomes headmaster, his pay is scaled. So after 8 years, he becomes senior grade. That is an incentive. Again, after 16 years, he gets another 6,600, another incentive. He is getting 2 incentives. Here we're getting only 1 incentive. In serial number 3, the headmaster, entry level of headmaster's pay is equivalent to selection grade teacher of high school. Sorry, high school. High school headmaster, entry level pay is equivalent to high school selection grade teacher. Then the headmaster gets an incentive after 8 years. Again, he gets an incentive after 16 years. So he is getting, if not 2, at least 1 incentive during his tenure as a headmaster.
So you are mainly aggrieved that you are deprived of incentive.
Yes, because they are giving it to everyone. Why not to us also? What is the reason? I mean, the reason given by them in the affidavit is totally arbitrary. Though they are pointing out the pay anomaly between the teachers and headmasters of high school, middle school. The pay anomaly has been already rectified by them, in fact, by giving double increment to headmasters of middle school earlier. Then, to satisfy them, they gave them 3-tier grade pay system. So, I mean, some incentive should be given to us also. We are also working for them.
But giving incentive is a policy decision.
So, Your Worship, that is why if I may take a lordship to 2002, volume 6 SCC. (2002),
2002.
volume 6
6
SCC, page 72.
Page 72. Yes. Para?
Para 10, page 79.
Yes, what it
I'll
said.
read para 10, Your Worship. Page
Yes.
79, para 10.
Yes.
It is at the bottom of the page.
Yes.
It is to be kept in mind that claim of equal pay for equal work is not a fundamental right vested in any employee, though it is a constitutional goal to be achieved by the government. Fixation of pay and determination of parity in duties and responsibilities is a complex matter which is for the executive to discharge. While taking a decision in the matter, several relevant factors, some of which have been noted by this court in the decided case, are to be considered, keeping in view the prevailing financial position and capacity of the state government to bear additional liability of a revised scale of pay. It is also to be kept in mind that the priority given to different types of posts under the prevailing policies of the state government is also a relevant factor for consideration by the state government. In the context of the complex nature of issues involved, the far-reaching consequences of a decision in the matter and its impact on administration of state government, courts have taken the view that ordinary courts should not try to delve deep into administrative decisions pertaining to pay fixation and pay parity. I'll lay stress on this here. That is not to say the matter is not justiciable or that the courts cannot entertain any proceeding against such administrative decisions taken by the government. The courts should approach such matters with restraint and interfere only when they are satisfied that the decision of the government is patently irrational, unjust, and prejudicial to a section of employees, and the government, while taking the decision, has ignored factors which are material and relevant for a decision in the matter. Even in a case where the courts hold the order passed by the government to be unsustainable, then ordinarily a direction should be given to the state government or the authority taking the decision to reconsider the matter and pass a proper order. So, Your Worship, when the decision is patently unjust or irrational, courts can interfere and direct the government to reconsider the matter. So, my humble prayer, Your Worship, is that since the decision is so unjust, while giving incentive to headmasters of middle school, high school, ignoring us.
How long a person remains? What is the tenure of a principal of higher secondary school?
If Your Lordship will,
Normally,
if Your Lordship will allow me to take Your Lordship to the petition filed by me, at para 4.
yes.
Para 4, Your Worship. So they are all, the petitioners are all working as principal government higher secondary schools. They were promoted on different dates. Page 6 is the table, Your Worship. Petitioner number 1 has been working as the principal of the Government Republic Higher Secondary School since 21st September 2010. The petitioner number 2 has been working since 2013. Petitioner 3 has been working as 2014. So, Your Worship, like that, they have been working for quite some time now.
What was relevant is their date of retirement.
I'm sure petitioner 1 and 2 will be, even 3, 4 will be quite near to retirement by now.
Yes. Because if the tenure is longer and no incentive is given to you
Yes.
for a long period, that may be a strong point in your favor. But if the tenure is shorter,
Yes.
and when the post is itself a post which can be manned only by a senior lecturer, after he already enjoys 3 incentive as lecturer, whether you stand in the same footing or not, that is to be seen. Okay.
Even the middle school teachers, high school teachers, they enjoy the 3-tier grade pay. Once they are promoted to headmaster, again they enjoy another 3-tier grade pay.
Okay.
So I mean, even while they're teachers, they're enjoying 3-tier grade pay. When they're promoted to headmasters, again they're given 3-tier grade pay. Here, the lecturers in higher secondary schools are admittedly given 3-tier grade pay. But once you're promoted to the post of principal higher secondary school, the 3-tier grade pay system has not been given to them.
Okay. Okay.
I'll leave it up to you, Lordship.
Heard Mr. A.R. Malhotra, learned counsel for the petitioners. Also heard Ms. Vanessaami, learned government counsel representing the state respondents. Hearing concluded, judgment reserved. I am reserving the judgment.
Orders, item 14.
Yes.
Please, Your Lordship. My Lord, this is an application for condonation of delay of 91 days in filing the connected appeal. That is the judgment dated, an appeal against the judgment dated 2/5/2024.
You have filed additional
Yes, my lord.
affidavit?
Yes, my lord. The additional affidavit will explain the time period from May to September, and the main application will explain the delay from September to October. My lord, liberty was granted at the
Who is appearing for the respondent?
Mr. Jonathan, my lord, he is appearing.
Yes.
Yes, my lord. May I start with the additional affidavit
Yes.
from the third
How much was the delay?
91 days.
Yes.
Yes, the third paragraph. The third paragraph. The applicants were aware of the judgment and decree dated 2/5/2024 passed by the Civil Judge, Senior Division 3 in Manisud number 11 of 2020 around the 9th of May, that 2024, that is a week after the pronouncement of the same. The counsels engaged in the trial court had imparted the information to them, and during
Where
that
are you
time,
reading?
third paragraph, my lord,
Third.
the additional affidavit.
Yes.
And yes, my lord, the counsels engaged in the trial court had imparted the information to them, and during that time, the applicants were both in their respective address. The fourth paragraph. The appellants were both from distant places. As mentioned, the applicant number 1 resides at Tuipang, El Siaha district, Mizoram, while the applicant number 2 resides at Beliang, Tripura. The applicant number 1 imparted the information to the applicant number 2 on the same day through telephonic communication, with an attempt to decide the matter and meet personally by the end of the month. However, monsoon season approaches and a sudden approach of Cyclone Remal greatly hampered the plan of both the applicants. The cyclone causes broad blockage in the connecting roads of Jampui Hills, as there were several landslides in the area, and the same issue was faced at Siaha district, Mizoram, causing certain blockage which hampered transportation greatly. It was only on the second week of June, that is on 11/6/2024, that both the applicants met and have a conversation of their case at Aizawl, Mizoram. The fifth paragraph. That at the initial, both the applicants decided to pursue the appeal separately since they felt that there could be conflict of interest, and they parted ways in that regard. The applicant number 1 consulted Mr. Larinlu, advocate and a resident of Bongkon, for pursuing the matter around 3rd week of June, and the files were given to him for his perusal. However, the counsel returned the files to the applicant number 1 after around 2 weeks and told that since he is not very acquainted with the proceedings of the appellate court, he advised her to approach other legal counsels, and even gave contact numbers of legal practitioners to the applicant number 1. Also, the counsel told her that he was reluctant to take up the matter since the opposite counsels in the trial were his former colleagues. An affidavit is annexed in that regard, my lord. And the 6th paragraph. By the end of June 2024, the applicant number 1 was down with peripheral neuropathy, a condition where the nerves outside the brain and spinal cord, peripheral nerves, are damaged, leading to symptoms like numbness, tingling, and pain, often in the hands and feet. She had to tend to her illness, due to which she made a frequent visit to a medical practitioner. That around 3rd of July 2024, the applicant number 2 contacted the applicant number 1 from his village and told her that since he has no knowledge as to the court proceedings, he felt it would be best to pursue the matter together, and that she would best handle the matter for him as well. Also, she did not idly sit at home. Sometime in the 2nd week of July 2024, she contacted her trial lawyers again regarding the steps to be taken in the case. However, since the said counsels confined their practice in the trial court only, it was advised that another counsel be engaged to pursue the matter. By then, the time period for filing of appeal, that is 90 days, has almost elapsed, since the same ought to have been filed on or before 31/7/2024. And paragraph 8. Things took a sudden turn when her sister, Deng Chini, was diagnosed with cancer following a biopsy report dated 18/7/2024. And being her closest amongst relatives, she had to tend to her sister, who took several treatment and tests during the span of July 2024 till around September 2024. The frequent visit to hospitals does not enable her to have a clear thought regarding her case, and since her bedridden sister always requests her company, the applicant number 1, accompanied her to almost every visit to medical institutions. And here at page 6, my lord, the frequency of visit, the dates on which hospitals were visited, medical institutions were visited is, there's a table. This shows that the time period expands from 8 July up until 18 October 2024, and medical certificates are annexed accordingly. And that during this, paragraph 9, that during this time, the applicant number 1 did not sit idly but gave her thought on her case, but could not find a suitable counsel who is willing to take up the case pro bono. To make matters worse, the applicant number 1 was summoned to the Court of Civil Judge on 5/9, wherein the plaintiff respondents have filed an execution proceeding against them. She contacted the applicant number 2 to appear on the date as well. However, he could only proceed for Aizol and reach on the evening of 5th September 2024, due to which the applicant number 1 alone appeared before the execution court. Here, they were made aware of the services of the legal aid facilities and that both the applicants approached the High Court Legal Services Authority on 6 September 2024 and filed their application for legal aid services. And, my lord, it is my prayer that the additional affidavit, with regard to this additional affidavit, the time period spanning from May to September be considered as sufficient for condonation of delay. And in the main IA, my lord, the main contention in the main IA is that after the legal aid counsel, Mr. Bishwa Joy Chakma, was appointed for them on the 6th of September 2024, he did not take steps for filing the appeal. And in fact, Mr. Bishwa Joy Chakma had left for his hometown at Kamalanagar, that is in the southern part of Mizoram. And accordingly, I was appointed for them to pursue the matter. And that same has been filed on the 28th of...
What is the main matter?
Well,
what is the impugned judgment?
it's judgment regarding money suit.
You were the plaintiff or defendant?
I am the defendant. I am the judgment debtor.
Judgment debtor.
Yes, ma'am.
Okay. Now execution case has been filed.
Yes.
What is the stage?
No adverse order has been passed as yet, but
Your Lordship, the case has been kept in abeyance due to the appeal.
Is there any stay?
no.
No stay, but the civil court has kept the case in abeyance.
It has passed an order of abeyance.
Yes, Your Lordship.
Okay. Then what is your submission?
Your Lordship, with regard to the submissions made by the counsel for the applicants, with regard to paragraph number 3 and 4, wherein it has stated that the judgment was received on the 9th of May after a week of the pronouncement of judgment, and regarding the fact that they were both in distant places, I have made a submission in...
You use
I have
my
filed-
microphone. Yes.
I have filed an additional affidavit, written objection to the additional affidavit filed by the applicants, which is at page 2 of the additional affidavit, written objection, page 2, para number 5. If I may read, Your Lordship. In response to the contents of paragraph number 3 and 4 of the affidavit, it is submitted that the applicants did not take effective steps for filing of the appeal. Even though the applicants have alleged that they had faced problems with meeting up personally due to Cyclone Remal, nothing has been placed on record to substantiate this claim. There is nothing on record to show that the parties were unable to meet for over 30 days on account of the alleged landslides. Lordship, as I have mentioned in this written objection, nothing has been annexed in the additional affidavit that Cyclone Remal had impaired their abilities to meet up during the alleged Cyclone Remal. And in response to the contents of paragraph number 5, I have mentioned that the counsel for the respondents had approached the brother-in-law advocate, but as far as I can recollect, Your Lordship, he was a part of our law firm during that time. So it is
He was part of?
a part of our law chamber during that time. Larin-Lua, Mr. Larin-Lua was a part of our law chamber at that time. So it would not have taken him over 2 weeks to decide and look into the matter that he was so and so during this time, because he was our former colleague, as also it has been admitted in the last sentence of the additional affidavit. So although I do not have proof that he was there and he was a signatory to the Vakalat Nama, but as far as I can recollect, he was also a member of our law firm at that time, and I believe he was a signatory in that time, and he would not have taken 2 weeks to come to that conclusion that he was a part of our law firm during that time. And in response to the contents of paragraph number 6 of the additional affidavit, regarding the medical condition of the applicant number 1, no documents have been annexed regarding the illness suffered by the applicant number 1. So this is without any corroboration on a part of the applicant number 1. And with response to the paragraph number 7 of the application additional affidavit, it is submitted that the applicants met around 11th of, as per the previous statement made in paragraph number 4 of the additional affidavit. The applicants met on the 11th of June, and it was alleged that they decided to pursue the matter separately, but it had taken them almost 1 month to decide that they would pursue the matter on 3rd of July. This goes to show that the applicants were sitting idly without having shown any effective steps taken by them, and there is no. This shows that they did not take any effective steps within the period of 11th June and 3rd of July during that time. And with regard to the averments made in paragraph number 8 of the additional affidavit, the applicant number 1 has failed to substantiate her relation to the alleged who was Deng Chini, who was alleged to be her sister. There is nothing to prove that she is the sister of the applicant. The application has merely annexed some medical documents of the alleged Deng Chini, who was diagnosed with cancer. So there is nothing to show that she had any relation with the applicant number 1, or that she had accompanied her to for the alleged treatments. So there is no relevance with the instant application regarding the treatments of the alleged Deng Chini. Deng Chini.
She is stating, he or she, applicant is male.
Applicant number 1 is she.
She.
She
She
is stating that.
So on affidavit.
No, Your Lordship, she is not stating anything on affidavit.
The application is not supported by an affidavit.
Application is supported by an affidavit. Your Lordship.
So whatever she is stating on affidavit.
Yes. That is there, but there is nothing to show that she is the sister of Deng Suni, or that she had actually accompanied her to the medical treatments. There is nothing on that regard, my Lordship. Only the medical documents have been annexed.
Medical documents have been annexed.
Yes,
Okay.
Your Lordship. But there is no proof that she is the actual sister of the ailing Deng Suni. So it is my submission that there can be no concrete proof that she is the actual sister of the ailing Deng Suni, and that
How to prove it?
any form of identification, voter's ID stating that they are from both the same parents or something actually determining that they are from the same parents.
No, you are not saying that she is lying on affidavit. You are only saying that she has not adduced
Yes.
additional material.
She has no proof
Apart
regarding
from
the
her
same.
statement on affidavit, she has not, because whatever she is stating on affidavit is itself a proof.
Lordship,
You are not saying that this is not true.
I cannot say that this is not true, but I am stating that she has not provided any
Documentary
materials
evidence.
to
Okay.
provide that
Okay.
to support her contentions.
Okay.
And in response to paragraph number 9 of the application, it is submitted that the appellants did not make appearance before the court on the 5th of September, as alleged in the additional affidavit, which is supported by the order sheet of the execution court, which is at page 8 of the written objection. No, Your Lordship, sorry, page 7 of the application. If I may read, Your Lordship, on 5/9/2024, counsel for the degree holder is present, judgment debtor is absent, hence court is adjourned. So, Your Lordship, on this date, the judgment debtors were absent, but this may not have direct bearings on the instant application, because they filed the application for appointment of legal aid counsel on the 6th of September. And though I have stated in my written objection that the applicant number 2 did not file an application in his name, the same was not annexed in, the same was not provided to me in the copy of the written objection, additional affidavit filed by the applicants. But in my communication with the counsel for the applicants, the same was there. So, but Your Lordship, my submission is that even though the application was filed on the 6th of September, nothing effective was done until the filing of the instant appeal, which was after a lapse of over 30 days. So, there has been lapse on the part of the counsel and on the part of the applicants in filing the instant appeal. So, Your Lordship, it is my prayer that the application for condonation of delay may not be granted in this instant application, because the condonation has not been, the reasons for the delay have not been properly explained. And Your Lordship, in this regard, if I may be allowed to file judgment of this concurrent bench.
Yes.
At page 8 of the judgment, Your Lordship. Paragraph 13, last line. The applicant was unable to file the connected appeal, and the reason cited in the applications is that a copy of the connected application in connection with the probate application was being applied for in the registry of the district court. The applicant has, however, not disclosed what documents were applied for, when the same was applied for, and when the same was handed over to him. The explanation made in paragraph 3 of the application, as abstracted herein above, is therefore very sketchy and not satisfactory. Your Lordship, in regard to this, the counsel had made an application. In the original application, he had stated in paragraph number 5, paragraph number 3, sub number 5 of his application, that, if I may read, the present legal aid counsel took immediate steps for filing of the appeal and obtained the necessary documents from the appellants on 5th October. However, it was learned that documents were not proper and crucial pages were missing, due to which an application for furnishing of copies of the documents in Manisud so-and-so was submitted on 14th October. An application for obtaining a certified true copy of judgment and order dated 2/5/2024 was also submitted on 14/5 so-and-so. The necessary copies were furnished to the council on 17/10/2024. It has not been mentioned that what pages were missing and what relevant documents were missing. And if I may continue reading the judgment at page number 10 of the judgment, paragraph number 15. Reliance has been placed on the case of Sri Devi Datla, wherein the apex court, in the given facts of the case, held that there is no straitjacket formula prescribed to come to the conclusion as to whether such sufficient and good grounds have been made out to condone the delay. The same has to be judged amongst others from the behavior of the litigant who seeks condonation of delay and who should display bona fides, and that they should not be any negligence in approaching the court at the earliest. As already stated herein above, the applicant, besides stating that preparation was made to prefer an appeal before this court by applying all the connected documents before the lower court, has not given the minimum particulars to substantiate his stand. Therefore, it only appears that there has been negligence on the part of the applicant in not approaching this court soon after he came to learn about the impugned order on 5 so-and-so. The apex court in Basawarajaj and another held that it is the duty of the court to exercise its powers judiciously based on the facts and circumstances of the case, and that sufficient cause cannot be liberally interpreted if negligence, inaction, or lack of bona fides is attributed to the party concerned. Even though limitation may harshly affect the rights of the party, but it has to be applied with all its rigor prescribed by the statute. Courts do not have the power to extend the period of limitation on imputable grounds. And it was on these grounds that the concurrent bench had rejected the condonation of delay at page 13 of the said judgment. So, Your Lordship, even in this case, it is submitted that the applicants have failed to provide any reasonable cause to condone the sufficient cause to condone the delay of 91 days in filing the appeal, as the medical conditions which have been alleged and the medical condition of the sister as well as the applicant number 1 as alleged in the application have not been properly verified, accompanied by any supporting documents. So it is my humble submission that the application for condonation of delay may be rejected at this stage.
You want to say anything?
Yes, may I rebut the submission regarding the missing documents, my lord. It's a common practice that certified copies and the missing copies are usually obtained from the trial court through an application through proper challan. So that has been done on the 14th of October 2024. And here, my lord, I have specifically mentioned that an application for obtaining a certified copy of judgment and order dated 2/5/2024 was also submitted on 14/10/2024. All the requisite documents were applied for in that application. Records can be called if in case there's a doubt regarding that issue. And I would like to rely upon one citation, 1987 True SCC 107.
Page,
Paragraph 3. Regarding
what it
condonation
says.
for delay. Condonation for delay.
What it says.
Yes. May I read, my lord?
Yes.
Paragraph 3. The legislature has conferred the power to condone delay by enacting Section 5 of the Limitation Act of 1963 in order to enable the courts to do substantial justice to parties by disposing of matters on merits. The expression sufficient cause employed by the legislature is adequately elastic to enable the courts to apply the law in a meaningful manner which subserves the ends of justice. And my lord, there are 6 parameters which has to be considered in taking a liberal approach. My lord, may I read the points?
Yes.
Ordinarily, a litigant does not stand to benefit by lodging an appeal late. Refusing to condone delay can result in a meritorious matter being thrown out at the very
Which
threshold.
parameters covers you?
My lord, in this case, firstly, in point 1, my lord.
One does not cover you. You are judgment debtor. You will be benefited if any delay is caused.
Yes, my lord, but
You may cause
there
intentional
could be an
delay.
adverse order if the appeal is filed late, late filing of the appeal. That is one contention, my lord. And 2, refusing to condone delay can result in a meritorious matter being thrown out at the very threshold and cause of justice being defeated.
On what ground you have filed the appeal?
My lord, firstly, jurisdiction, place of suing, and foundational facts are not properly established. That is 2 of my my grounds.
Okay.
Yes, my lord. And my lord, this is a fit case for exercising positive discretion, my lord. That is my submission. Though it is a delay of 91 days, that is inclusive of holidays and non-working days. And subtracting such days, it only amounts to 66 days, as per my calculation. So, Lord, you may kindly allow the matter to be condoned. Duration of delay, condoned.
You are
26.
Mr. Jonathan. Okay, I'll pass orders in chambers.
Yes, Your Lordship.
Today itself. You have to wait.
Yes.
Obliged.
Item number 15.
This I've given chamber. Item number? Yes, what is this?
Lordship, this can come up at 2 o'clock, Lordship.
Yes,
It's already 1 o'clock.
we'll take it up at 2.
It's another condonation of delay application
By the union,
by the union.
you are opposing.
I'm opposing vehemently.
Okay, we'll take it up at 2. During,
They said for
during
tomorrow.
lunchtime something happened.
Yes. She have fever and headache now.
Tomorrow?
Yes, for tomorrow.
Maybe. Okay. Yes, Miss.
Tomorrow?
Not tomorrow. Next
Thursday.
week. Next week.
Next
Tomorrow.
week. If your lordship can have it on Thursday, next week only Justice Murli is here.
She cannot take it up.
Cannot.
Then tomorrow.
Tomorrow.
Tomorrow, is it okay or
Yes, my
Thursday?
lord. Thursday.
Tomorrow?
Yes, tomorrow, my lord.
She'll be okay.
I hope so.
Heard, Miss, what is your name?
Baby Laldin Zwali.
Baby Lalrin Zwala. Learned Counsel appearing on behalf of Miss Zairem Sangpoi. Learned
CGC.
Central Government Council. Also heard Mr. A.R. Malhotra, Learned Counsel for the opposite parties. Learned Counsel for the applicant has submitted that Ms. Zairem Sanpui is not feeling well and therefore had to leave the court early. And on that count, she prays for an adjournment. The prayer is not opposed to by Learned Counsel for the opposite party. Hence, same is allowed. Let this matter be listed. Let it be on Thursday.
Okay.
Let this matter be listed on Thursday is 26th of June 2025.
Item number 16 and 17.
Yes.
May it please your Lordship. Lordship, this is an IA filed under Section 528 of BNSS for the release of the trade license, my Lord, which has been impounded by the trial court under the name of Mercy Petcare, my Lord.
My Lord, I have received the application on behalf of respondent. If I may, given time to file
You'll be
objection.
filing written objection.
Yes, my Lord.
Okay. In item number 15.
16.
Item number 16. Heard, Miss, what is your name?
Daphne Leshuaitlong, on behalf of my senior, Mr. Jesse Renansanga.
Right, you write her name. Submitting on behalf of Mr. J.C. Lalnan Sangha, Learned Counsel for the petitioner. There are two ayes. No, only one aye.
Only one, my Lord.
This interlocutory application has been filed in connection with criminal petition number 5/2025 by the petitioner praying for release of the trade license number AMC 03/00915/2014 under the shop name of Mercy paid care to the applicant during the pendency of the connected criminal petition. Miss
Bilaram Nemi.
B. Lalram
Nemi.
Nemi London. You are counsel, you are legal aid counsel.
No, my lord.
You are appearing for
Respondent.
state is the respondent.
No, private respondent only, my lord.
Who is appearing for the learned counsel for the respondent. Praise for allowing the respondent to file a written objection against the prayer of the petitioner for release of the trade license. The prayer is allowed.
My lord, if the matter may be fixed on 17 July, my lord.
17 July.
Yes, my lord.
No objection.
You'll be happy. The prayer is allowed. Let this matter be listed again on 17th of July.
Oblige.
TP oblige.
Item 18.
This lordship is a bail petition, lordship.
Who is for the state?
I furnish copy to the learned PP, Mrs. Linda, lordship.
But stay. What is the?
Now this is the first time, lordship. Notice may kindly be issued, lordship.
Okay. What is the offence?
The offence is under NDNPS section 21C, lordship. Brief story, lordship, is that
Matter is pending investigation or charge sheet has been. Whether investigation is pending or charge sheet has been laid.
As far as I know, my lord, charge sheet has till now not been filed, my lord.
Okay, heard Mr. C.
Zoram
Zoram Chana, learned counsel for the petitioner. Stop. This petition under section 483 of BNSS has been filed by the applicant Shri Vanlal Chandama,
yes.
who is detained behind the bars since when?
25 September 2024.
Since 25 September 2024 in connection with
Sessions case number
23
of 24.
/2024 arising out of excise case number EX 172/2024 under section 21C of NDPS Act 1985. It is pending investigation. Case diary would be required.
Yes, my lord. It's ongoing investigation.
Stop. Also heard Miss Linda L. Farmwell, learned public prosecutor.
Apologize, Your Lordship. I made a pleading that charge sheet has now been filed, madam.
Charge sheet has been filed.
Madam.
What is your ground?
My ground is that notice, the ground of his arrest, my lord, was not furnished at the time of his arrest, Your Lordship.
Then scan copy of the case diary would be still required. Or you can produce the case diary from the trial court.
I'll try, my lord. Yes.
Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Learned public prosecutor shall produce the case diary on the next date fixed when
Maybe next week, any date, my lord. Or day after next.
Next week, I think.
You suggest a date?
Week after next, maybe.
3rd of July.
3rd of July. Let this matter be decided on 3rd of July.
Obliged.
Hearing item 19.
Mr. Zoe.
My lord, we have hurriedly done the translation of the 161 statement of the respondents. There might be some mistakes. I have.
Keep it in my chamber. This is in relation to that condonation, that matter which I have reserved. Yes. No.
The translation, I forwarded a copy.
Yes, I.
Yes, Your Lordship. This is the statement, the page number 1 is the statement of the respondent number 1. And he has admitted that the project fund was distributed. He admitted that he was responsible during this time, my lord. He was the PIA, District Horticulture Office. He was as a District Horticulture Officer, my lord. He was the project implementing agency from January 2006 to July 2006. And he admitted that they have received 66 lakhs as first installment.
And thereafter?
And my lord will see that at page number 1 is the question. You are holding the post of DHO PIA till July 2006. During your tenure as PIA, the Nodal Department PD DRDA has sanctioned an amount of rupees 66 lakhs as first installment. From the sanction order of the PD DRDA, the sanction money received can be utilized as follows. For work component is 44 lakhs, community organization and training 13 lakhs 20,000, and for administrative overhead 8 lakhs 80,000. The total of which is 66 lakhs from the vouchers, APRs, DHO, SAIHA. It is seen that during your tenure as PIA DHO, the expenditure amount was more than the sanction amount. What is here? It should be explanation here, my lord. Here, my lord, he has explained. I cannot cite the reasons on why the fund received and the expenditure amount does not tally. Like I have stated before, this project was under the guidance of 3 HEO, that is the Horticulture Extension Officer, and the 3 HEO are the respondent, present respondent 3, 4 and 5. And moreover, the project fund was handled by Puti Vanupa. He is the respondent number 3. All the money utilized are under the guidance and proposal of the 3 HEO. There were no project guidelines, survey and planning was done in accordance with the advantages of farmers and beneficiaries. After working for a while, it was necessary to work according to the project guidelines. Reports have to be given quarterly. Since quarterly reports have to be given according to the format, we have, should be adjusted here, madam. We have adjusted the APR to the best of our ability. This may be the reason why the sanction amount and expenditure vouchers, APR does not tally. The reason is that since there is no sanction, there is no money in the department for the implementation of the project. And your lordship will see that at question number 4 at page number 3.
Yes.
Question number 4. It is written that plastic chair, folding bed, dining table, drawing table, water filter, mosquito net, mattress and bed cover amounting to rupees 49,970 was purchased for disbursing to the watershed committee or the 5 village council from the administrative overhead. But instead, you have purchased several office items like steel almirah, table, revolving chair, Xerox machine and computer set. Is this correct? If it is correct, are you authorized to purchase these items? And the answer is, it is correct that we have purchased the above said items for the office, but we have no permission to purchase.
So, my lord, it is clear that they have diverted the funds on their own use, my lord, for their own use. And at the next
Not
question.
own use, for they purchased the office articles.
Yes, office things, but this was.
Maybe without authority.
Yes, there is no authority. They have diverse the fund, my lord. And at question number 5, at page number 4, my lord.
Yes.
From the expenditure head of community organization and training, it is seen that rupees 3,60,000 was used for the salary of MR laborers for survey and planning. However, in reality, no MR laborers were employed. What is the reason? And the answer is survey was carried out after knowing about the project, but before receiving the fund on October to November 2005. This survey was carried out by the 3 HEO by going to the spot, that is the respondent number 3, 4, and 5. Their expenditures were drawn out through MR bills. I am not aware that MR laborers were not engaged. So, my lord, the money, this 3,60,000, was not spent as written down in the APRs. It was used by the respondent 3, 4, and 5, since they were the person that had done the survey. And in the APRs, it's written as daily wages for laborers. This is the statement of the next statement is respondent number 2 at page 6. This is Mr. S.R. Lalrin Liana. My lord, we'll see that in paragraph number 3 of page number 6, he has stated that he took the charge of the respondent number 1 from July 2006. And he also admitted that this tree horticulture extension officer took the charge of the project. And your lordship will see that in the question that was asked, in question number 1 at page 7.
Yes.
On 24/11/2006, the state matching share, which was 6 lakhs, was noted in the joint account book, page number 7. On the same account book, page number 7, under the disbursement column, an administrative cost was for rupees 40,000, and the work component, which was rupees 4 lakhs. Total amounting to rupees 4,40,000 was noted on dated 25/11/2006 and was on 27/11/2006, where the expenditure was written down, and it appeared that it was your signature where you worked as DHO and PIA. Are you aware of how these funds have been used? And the answer has been given. I have been holding the charge of DHO Siaha since 31st July 2006, that is after taking charge from the first respondent. As I have previously mentioned, I have very limited knowledge regarding the IWDP project. I am also not fully aware of how the project funds were managed, as the financial accounts were primarily handled by Putti Van Upa, HEO, during the tenure of the former DHO, Arzo Tona. I strongly put my faith on him. Moreover, as the overall implementation of the project was overseen by the project in charge officers, HEO Pusi Ram Rela and HEO Putti Van Upa, and since all project-related expenditures were made based on the demands and requirements prepared by them, I believe these funds should have been released accordingly. To the best of my knowledge, since there appeared to be certain irregularities, and it appeared that they didn't want me to know, I did not interfere unless it was unavoidable. So he has fear from the beginning, my lord, in his own statement. And I'll proceed, my lord. Regarding the expenditure of the state matching share amounting to rupees 4,40,000, I had certain concerns and suspicions. Since the matter involved seniors and subordinates who had already carried out certain actions, I was reluctant to muddle up the situation. Moreover, I did not anticipate that such irregularities could escalate into complications or even result in ACB cases. Therefore, I chose to remain silent out of caution. However, on deeper reflection, I now feel that I should have spoken up and taken appropriate action. The reason is that the state matching share amounting to Rs 6 lakhs was released by DRDA Siha as per order dated 24/11/2006, and the disbursement was made using APR number 3 dated 22/12/2006. However, in the PIA joint account on page 7 under the receipt side, the entries recorded under a date prior to 24/11/2006. Furthermore, on the disbursement side of page number 7, it is recorded that Rs 40,000 was spent under administrative cost on 25/11/2006, and Rs 4 lakhs was disbursed under work component on 27/11/2006. This was clearly an irregularity. Moreover, the receipt and expenditure details of the state matching share, which were already countersigned by Puarzo Tona, was crossed out, and I signed it in my capacity as DHO only because I was requested to do so. I strongly believe that the inquiry from the DRDA should match the records collected from the inquiry. So, my lord, this respondent number 2 took charge from the respondent number 1, and he has stated in his statement that he was suspicious right from the beginning, and he was not involved in the first installment that they have received. However, my lord, his involvement is that he has given his signature because he was requested to give his signature. And from the statement of respondent number 3, my lord, this is T. Vanupa. He was the one who handled all the project fund. We can see that he has not denied, my lord. In page number 12, question number 1. At the bottom, page number 12. After you had received the project fund from the DRDA, is the money handed over to the office cashier? And the answer is no, it was handed to me. Because it is a project fund, the department cashier did not touch anything. So, my lord, he was the one who handled all the cash transactions here. And at question number 7 at page 15, this is the statement of the same respondent number 3. Question number 7 at page 15.
Yes.
Question number 7 is, if that is the case, who signed the above mentioned APR? Answer is us. It was signed by any of the 3 HGO who was available at the time. So, my lord, they have admitted, he has admitted here, even the other 2 have admitted in their statement that they gave the signatures in the APR.
Whose signatures?
Their own signatures as those person receiving the money, the funds.
Stating the signatures to be that of beneficiaries.
Yes. Yes,
on behalf. They gave their own signatures.
Their own signatures in
lieu
the
of
APR.
Okay.
And my lord will see that they have diverted the fund without any authority. At question number 10, at page 16. Yes, your lordship got it, page 16. Several people mentioned in the APR of various expenditures maintained by you and countersigned by you and paid by me have stated that they have never received the money. What is the reason behind this? Is the APR for various expenditures fabricated? And the answer is work such as soil and moisture construction, water harvesting structure, afforestation and pasture development work under the work component was carried out. This work was used for creating employment for the whole village as far as possible. And since it was impossible to make APR under every individual's name, APR was made in the name of some well-known person in the village. However, the money was not given to those persons only. Moreover, the signature in the APR was also signed by us. Among the work component mentioned, one construction of water harvesting structure at Ainak was not carried out. So, my lord, he has not denied this. Under this work component, an arrangement was made for the construction of sub-center building for an amount of rupees 2 lakhs based on the needs and wants of the villagers and upon the approval of our leader. So he has accepted that they have diverted the funds for construction of sub-center building, rupees 2 lakhs. And at page 17, question number 12. To the question put before you in question number 10, you have answered that under the work component for water harvesting structure at Ainak village, you had constructed sub-center building. Who gave the authorization for that? Do you have the permission to divert funds? Answer. An application was made by Ainak VC to the project director, DRDA. The PD had also requested me verbally to make such arrangement as these are crucial needs. I did not have a separate diversion order. I have made the arrangement for diversion of funds as requested verbally by the PD DRDO. And I'll take your lordship to page number 18, question number 15. The next page. It appears that there are several funds diversion and misutilization in the way the project funds are utilized. Did the DHO have knowledge of the way the funds are utilized? Yes, he does. No funds were utilized without prior discussion and prior consent of the DHO. And at question 17, my lord, there has been all wrong names have been given in the supply and order bill. And the next page, page number 19, is the respondent number 4. They have admitted, my lord, in all the questions and answers put to them, my lord, they have admitted. It's all similar. And my lord, at page 32, this will be the last one, my lord. Page 32. This is the statement of the respondent number 5. Question 17. In several cases, individuals whose names were mentioned in the APR have stated that they did not receive any money. Some of the people whose signatures appear in the APR have claimed that the signatures are not theirs. Many have reported such discrepancies. Who have signed this APR? Answer is these signatures were usually done by us. And question number 20.
These are all accused persons.
Yes, my lord. These are the statements they have.
You are saying that they have admitted during 161 that they themselves forged the signatures of beneficiaries.
Yes, my lord.
Apart from their statement, what else is there?
Apart from their statement, my lord, we have taken the statement of those people whose names were given in the APR, and we have seized several documents, and we have.
Now, how will you prove it in the court? To find out whether there are sufficient grounds for proceeding. The only material is 161 statement of the accused. They will deny before the trial court.
They will deny, but the APRs, the signatures are there, my lord. The
Signatures, have you examined it?
yes, the FSL report is also there.
What it indicates?
It's all fake signatures.
But who faked those?
Those are not mentioned.
These are fake signatures.
Mhm.
But who faked those signatures? You have some lead in form of 161 statement of the accused. That accused are
They
admitting.
have forged it, yes.
But you have not forwarded them for recording their confessional statement, which could have been used as evidence.
That is true.
Now, suppose charges are framed. This is an order against discharge only, na?
Yes, discharge.
Now, how will you prove the case? You don't have materials. In the court, they will not say, they will deny.
They will deny. But my lord, the APRs, the documents are there.
Documents are there that these are fakes. These are not the signatures of beneficiaries. Then circumstances made it. Okay.
That may be there. But my lord, at the stage of framing of charge, those cannot be considered, my lord.
At this stage, the court cannot consider these things.
So our main prayer is that, my lord, at least charge should be framed at the stage of consideration of charge. And
Accusation is there that you forged the document. Whether in charge sheet any accusation has been made that the accused persons have forged the signatures of beneficiaries. Any such accusation has been made in the charge sheet.
yeah, I think it's there, my lord.
The charge sheet was laid under what provision? Under section 368, 371, no 468,
468, 471.
477. Okay. Anything else?
So, my lord, my prayer is that since it is clear from the reports that there was some misutilization of funds, but after interrogating the respondents, my lord, we could not be able to pinpoint how much fund one person is misappropriating. That is why, my lord, collectively we have made them liable. And it is clear from their own statement that they have diverted some funds and used it for some other purposes. And this amounts to corruption. So if charge may be framed, that is my prayer.
Lord, if I'm allowed to submit few more things, my Lord. Your Lordship, in order in respect of the 161 statements, which the learned PP had read and mentioned about, Your Lordship, my humble submission is that before coming to the fact that 161 statements, particularly the accused statements under 161 CRPC, it could not be reliable at all. Before coming to that ground, I'll be relying upon one citation in that regard, my Lord. First of all, I would like to submit that expenditures were made and no misappropriation of fund was happened, Your Lordship. It didn't happen because, as we have seen the 161 statements of the accused persons, respondents herein, my Lord, there were actual expenditure for the purposes, but which may not be as per the project implementation. Maybe diversion of funds may be there, might be there. However, Your Lordship, there is no personal gain for the present respondents. They did not take any single amount, and there was no admission to that effect, my lord. So that is the point I would like to take out. And my lord, regarding the forgery, alleged forgery of documents, it was clearly mentioned that those particular funds were utilized for the whole village. The whole village were employed to work some particular works, and it was used for the benefit of the whole village. So it could not be possible to obtain the APR, the signatures in the actual pay receipts. Every villages, it was not possible for the PIA to get their signatures. So signatures were made.
Who made the signatures?
Then, although the accused person, particular accused person, said that this is signed by us, that particular word, collective noun, us, was made, my lord. So there is no distinct and specific mentioning who forged, who
120B
signed.
comes.
Yes.
So it will be tried collectively.
But your lordship, while saying this, what I would like to point out is that there is no, whether it could be termed as the forgery also, because it was actually used, there is no personal gain, there is no conspiracy for that, my lord. There was no misappropriation of fund.
But forgery was there.
But it was only for the, by looking at the 161 statements only, my lord, it was done only for that purpose. Because in order to make it compromise with the actual fund utilized, then the receipt should be there. So only for that purpose. So my lord, and these are the 161 statements, particularly in respect of the accused persons who are the respondents herein. If I may take your lordship again to page 54 of the revision petition, my lord. In spite of all these 161 statements, what the case IO had concluded, the investigation report is, although yesterday we have gone through this, my lord, I may refer this again.
Page number?
Page 54, 54 of the revision petition, my lord. This is the conclusion of the investigation report.
Yes.
My lord, the third paragraph, it starts with during investigation, my lord. Has your lordship got it, my lord?
Yes.
During investigation, it is found that the PIA had committed offence under sections 468, 471, 477A IPC by forging signatures of beneficiaries and water development team WDT members and prepared fake APRs, specimen signatures of 23 beneficiaries and approved signatures of 9 WDT members. Employees of the PIA were collected and sent to Forensic Science Laboratory Aizawl along with suspected APRs for comparison, and opinion handwriting expert from FSL Aizawl opined that all the signatures of the APRs except handwriting expert from except signatures of Pu C Lai B, son of so and so, secretary Nathiel Lui, Micro Watershed Committee were forged, Vice Joint Directors FSL Aizawl memo number so and so, dated the 26th February 2014. Mention may be made that as per handwriting expert opinion, beneficiaries and watershed committee leaders, especially from Lungbun village, who had admitted to have received the amount shown as paid to them and signed in the APRs, while receiving the funds do not match with their specimen signatures obtained during investigation. Further, Pu Arzo Tona, DHO Saiha, had relinquished DHO Saiha just to Pu SR Lalindiana on 31/7/2006, but had countersigned in the cash book PIA account till August 2006, September 2006, October 2006, November 2006 and December 2006 beyond his tenure as DHO Saiha. Hence, a prima facie case is found well established against. The names are given. These are the respondents, my lord. And the last line is, sentence is criminal conspiracy for committing misappropriation of funds under Hariali Project 5, Saiha District 2005-6, amounting to rupees 15,81,222, which is liable under section 120B IPC. So my lord, what I am trying to point out is that out here what it is generally mentioned is that these the specimen signatures, comparing specimen signatures taken and those signatures which were in the APR, then they were not matched, my lord. So although it appears that it was forged by someone, but there is no particular allegation amongst the accused, the 5 accused persons, accused 1, 2 or 3, 5, 4 or 5, who forged the signature. It was not given, my lord. So that was why yesterday also I pointed out that Honorable Apex Court's judgment saying that in the charge sheet it has to be mentioned clearly, separately, which of the accused persons had committed that particular offense and what particular offense was committed by which accused persons amongst the 5 accused persons. All this had to be have to be properly mentioned in the charge sheet, my lord. In spite of that criminal conspiracy accusation, but 468, 471 and under PC Act also, my lord, these are the other allegations are there. So this is my contention, and my lord, apart from what I have said, another point is that whether these 161 statements of the accused persons could be relied upon. In that regard, my lord, I may cite this 2025 SCC online, SC 1157. 2025 SCC online, SC 1157. Paras 42 to 47, my lord. I may read this. Paras 42 to 47. Your Lordship, although this pertains to the relevancy of the 161 statements for the anticipatory bail, but it helps my present case also. That's why I would like to read out, my lord, because it could be applied in the present matter as well. Yes. My lord, may I start from para 42? It is no more res integra that a person who is accused of an offense or named in the first information report can be examined by the police, and his statement may be recorded under section 161 of the CRPC. In this regard, reliance may be placed on the decision of this court in Nanidi Satapathy, so and so, so and so. However, the question as to whether such a statement of the accused is admissible in law and in what manner can the same be looked into was explained by this court in so and so case, wherein it was held that as per section 162 of the CRPC, no statement made by any person to a police officer in the course of an investigation shall be signed by the person making it or used for any purpose, any inquiry or trial in respect of any offense under investigation at the time when such statement was made. The only instance when such statements may be considered or looked into has been provided in the proviso to subsection 1 of section 162, which permits the use of such statement or any part thereof to contradict such witness in the manner provided by section 145 of Evidence Act, or in the re-examination of such witness for the purpose of only of explaining any matter referred to in his cross-examination. A statement given by an accused to the police under section 161 of the CRPC may be either in the form of a confession or an admission. The private counsel in so and so case explained that a confession is a statement admitting the offense, or at any rate substantially all the facts which constitute the offense, whereas an admission is only in respect of a gravely incriminating fact. Even a conclusively incriminating fact is not of itself a confession, whereas such statement is a confessional statement. The rigor of sections 25 and 26 will apply in full force, and the said confession would be completely inadmissible as held in Sahib Singh Supra and a catina of other decisions of this court, where, however, such statement amounts to an admission. The statement, being one under section 161, would immediately attract the bar under section 162 of the CRPC, and the same may be used only for the very limited purpose provided in the proviso and held in Mahabir Mandal Supra. We are conscious of a handful of decisions of this court wherein it has been held that statements under section 161 of the CRPC ought to be looked into by the courts in deciding the question of grant of bail. So and so 2022 SCC Online SC 241 observed that statements under section 161 CRPC may not be admissible in evidence but are relevant in considering the prima facie case against an accused in an application for grant of bail in case of grave offense. Similarly, in so and so, reported in so and so, it was held that the court is in duty bound to consider all the statements recorded under 161 CRPC, examine the gravity of the offense, and also examine the question of possibility of the accused tampering with the evidence and possibility of getting the attendance of the accused during trial, and then would be entitled to grant bail to an accused. I would like to stress on this para 45, my lord. However, the aforesaid observations cannot be singled out and construed devoid of its context. While it is permissible for the courts to examine the statements recorded under section 161 of the CRPC for the purpose of ascertaining whether a prima facie case has been made out against the accused and the nature or gravity of the allegations, the same applies only insofar as such police statements are of witnesses and not accused persons, my lord. This is what I would like to stress upon, my lord. The same applies only insofar as such police statements are of witnesses and not accused persons. Para 46. Both Indresh Kumar Supra and Salim Khan have held that in deciding the question of grant of bail, it is the statements of witness under section 161 of the CRPC that has to be looked into. Nowhere has this court held that even the police statements of the accused persons under section 161 of the CRPC must also be looked into at the stage of grant of anticipatory bail or regular bail. This is because a statement of an accused under section 161 of the CRPC stands on a different footing from a police statement of any ordinary witness. Statements of an accused person under section 161 of the CRPC, by virtue of ordinarily being in the form of either an admission or a confession, cannot be looked into qua another co-accused. As to say otherwise would be to ignore the substantive provisions of sections 17, 21, 25 and 26 of the Evidence Act and the well-settled canons of law of evidence. However, the aforesaid does not apply where the statement of an accused under section 161 of the CRPC is exculpatory in nature, which we shall discuss later. So, my lord, what it basically says over here is that in this citation is, if 161 statement, if it is to be taken in respect of the accused persons, that cannot be used
even to come to a conclusion that there is a prima facie case.
Yes, to see whether prima facie case is there. But nowhere in the present case, the other witnesses recorded under 161 statements, it didn't specifically stated that this person among the accused persons had forged this signature, or he had misappropriated this amount. No other 161 statements were relevant, my lord. So what I'm saying is that although the accused persons, the accused number 2 is pointing finger to the other accused persons, the present respondents, but that cannot be used as the evidence or to see the prima facie to incriminate the others or to see whether prima facie case is there in the present matter. So this is what the present judgment has said, my lord. So my prayer is that it may kindly be upheld, the discharge order, my lord.
My lord, if I may, the statement which we have pointed out was only to clarify that they have made certain diversion and they have misappropriated some amount. But the question remains is that, my lord, out of the 72 lakhs, all this work component, community organization and training, administrative overhead, the expenditure, the remaining expenditure is 15 lakhs. This was not found anywhere.
This was for the investigating officer to find out where it has gone, how it has gone.
This could not be found.
When the witness answered him that we have done it, we have signed it, some accused has stated to him that we have signed it.
Yes.
He should have questioned him.
My lord, that is the
Specifically.
APR that was available. As we can see from the charge sheet at page 53, my lord, all these work components, the APRs were all there. But the question that was put in the 161 statement is with regard to all this work component, community organization and administrative overhead. Now, my lord, the remaining 15 lakhs is still missing. That is what I wanted to point out. And from their statement,
No,
they are all accountable.
that remaining 15 lakhs has been diverted for purchasing fax machine, scanner,
No, my
Almira.
lord. Here, your lordship will see that all the question that has been put is that it's in the work component and community organization.
Which?
My lord, for purchasing all those in the administrative overhead at C, serial number C, shown as being the cost of household goods supplied to the project beneficiaries, but actually utilized for purchase of office furniture, computer set, and Xerox machine.
Which page you are reading?
Page 53 in the charge sheet. Page 53.
Yes.
Yes, my lord. At administrative head, the third heading, my lord. Administrative head at column C is for the office furnitures.
Yes.
And vehicle hiring charges also is in the community organization and training. And the honorarium of WDT members, which they have mentioned in the 161 statement, is also under the administrative overhead. So all the expenditures which was put to question in the 161 statement is under all these heads, my lord. However, the remaining balance is still there despite all this, my lord. Remaining balance is 15,81,222.
No, okay.
However, Lordship, assuming this is true, assuming for a moment this is true, but there is no indication that out of 15 lakh something, then who misappropriated what particular amount, my lord? Jointly it was the church, the accusation was made jointly and generally against all the accused persons. That was the main reason why the learned trial court had also said that by relying upon the Honorable Apex Court decision, then it could not be, church could not be framed. Because, my lord, if we look at 211.212 CRPC, it is very clear, it has to be specifically mentioned. So there is no reason why church should be framed. And it was justified by the learned trial court itself, why church was not framed.
The reason why it's not separately mentioned, that is why, my lord, I have produced the statements. It's difficult to pinpoint exactly the amount which they have misappropriated.
Okay, I'll go through it. Suppose an FIR has been filed that my watch is missing from my guest house where I'm staying. The investigating officer comes and finds out that watch is really missing. He finds out, he interviews who are there staying in the guest house. Say there are 5 to 6 persons staying in the guest house. He takes statement of each one of them and file charge sheet against each of them without verifying who has stolen the watch. The fact that the watch is missing, here the investigation is okay to the extent that 15 lakhs is deficient. But who embezzled that money?
Yes,
That part may perhaps be lacking.
That is why, my lord, I have brought out the statement where they have accepted that the tree horticulture extension officer, they were in charge of the project, which was under the DHO, who is the project implementing agency. And they are all responsible since everything was done in consultation with this persons. That is why I have pointed out.
Okay. Steno. But the fact remains that 15 lakhs were not utilized for the purpose for which it was sanctioned.
Yes.
And it is not accounted for by the persons who were accountable.
Yes. As per the findings of the case IO, yes, this is true, madam.
Item number 19. Heard Ms. Linda L. Farmville, learned public prosecutor appearing for the state petitioner, for the petitioner, that is the state of Mizoram. Stop. Also heard Mr. B. Lal Remenga, learned counsel for all the respondents. Hearing concluded, judgment reserved.
Highly obliged, ma'am.
Hearing item 3 and 4.
Three and 4 from the hearing list.
My Lord, these are analogous matters. Regular first appeal.
Lordship, with regards to item number 4, RFA 11 of 2013, I have, upon perusal, I have found that the paper book is not with me. I have not yet received the paper book.
These both are connected matters.
Yes, my Lord.
Why? Arising out of same judgment?
Different judgment, my Lord.
Then why they
but
are...
it's regarding contract matters, my Lord. I'm a contractor and I've undertaken some contract works under the state respondents. And it's regarding interest in the delayed payment, my Lord. I've submitted my bills and there was some delay on the part of the respondents. And my case is that I should be paid interest as per the contract agreement, which the state respondents have disputed. It may take some time, my Lord, these two matters.
Today.
It will require extensive...
You don't have paper book?
Yes, my lord, with regards to RFA number 11 of 2013.
You require that.
Yes.
Why you don't have? Registry has
Lordship,
not.
I have been recently endorsed to this case because this is a 2013 matter.
No, but whether the earlier government council was
Yes,
provided.
my lord, that is the problem. The earlier government advocate, I could not contact him.
So what is your submission? You have narrated your problem.
Yes, my lord.
But
If paper book can be furnished to me, I don't think it will be in the office either because I have checked it yesterday.
you have to get it Xerox yourself, government. You have extra copies.
Oh my lord, it's very bulky.
It's quite voluminous, my lord.
Okay. Heard. Mr. What is your name?
Si Tlan Thiang Lima.
Si Tlang Thiang
Lima.
Thima. Last portion is pronounced as?
Lima.
Lima.
Yes.
Thiang Lima, learned counsel for the appellants in both the cases 3 and 4. Also heard Miss Caroline, learned government counsel, appearing for respondent number 1 to 4. She submits that she has been newly engaged, newly interested with this matter, and she does not have the paper book of RFA number 11/2013. We have office copy paper book. Spiral binding.
Yeah, department expenses.
Registry shall provide. Registry is directed to provide a photocopy of the paper book to Miss Caroline within next 2 weeks. List this matter after that.
My lord.
After 2 weeks.
My lord.
Thank you.